Good morning all. This morning we have a hearing before Justice Sir Jeremy Cooke in the case CFI-048 of 2018 SKAT, the Danish Customs and Tax Administration, and Elysium Global and others. The claimant is represented on your right, Your Honour, by Pinsent Masons. Lead counsel is Tom Montague-Smith QC, assisted by Matthew Watson. The defendant on your left, Your Honour, is represented by Davidsons. Lead counsel is Nigel Jones QC, instructed by Andrew Lyons.
Good morning.
Yes.
As has been said, I act for the claimants. As you know, I'm here with Mr. Watson and Mr. Jones appears on behalf of the defendants. Your Honour, the first issue for today really is what is this hearing all about? You may recall what happened at the last hearing, and you'll see what we say about that. And we had this issue about the black box documents and whether they should simply be released to my clients. And as you've seen, my position on that was that that had already been ordered. But we didn't have time to complete the discussion at the last hearing.
No, but that's all effectively resolved,
well,
as I understand it.
The application is not conceded as such, but I would say the key tenets of my application are conceded. My application is put on in two alternative ways. One is that the document should simply be released.
Yeah.
There was an alternative which had a very long schedule of parties, and the idea was there would be a search. And it appears, but it's difficult to discern from my learned friend's submissions, that he favours the latter approach, but he has some suggestions to make. We were promised some suggestions in his skeleton argument, no suggestions that have been forthcoming today.
Well, let me tell you what my preliminary
Yes.
view was, because it seems to me the parties aren't very far apart in any event. But it appeared to be the right thing was for Schedule B to be extended, and the practical answer was to allow the first part of your
Yes.
application in any event, and that is effectively, I think, where Mr. Jones has arrived at, for entirely pragmatic reasons, without conceding anything at all, as can be seen from the annex to his SKAT.
Yes.
Now, if I've understood that rightly, effectively there's nothing very much between the parties. There may be some odds and ends in terms of ancillary orders and the like. But can I invite clarification?
Well, my preference, having given it some further thought, my preference is that the claimants proceed with their alternative, not their first one. So we concede the principle, so we're not standing on the paragraph 30 argument as we once were.
No.
And there might be some issues about costs about that, but that's not relevant for now. And I would like to, just a few minutes in due course to take you through why you say it should be alternative 2, not alternative 1.
No, well, I understand that.
Yeah.
Leaving aside whether there was agreement or not to the form of the order as it was,
Yeah.
in principle, I'm with you that that is the better approach. But the pragmatic answer at the end of the day appears to be to allow, and I think you accept this, but for practical reasons, matters to be dealt with in accordance with the first application rather than the second. And once I've granted the second application, the point essentially disappears in any event, doesn't it?
Well,
Have I misunderstood?
Maybe at cross purposes. As I understand it, Mr. Montague-Smith is contending for two possibilities. One of which is that he just gets all the documents released to him in the black box in any event, and he does what he wants with them.
Yes.
But I don't mean that pejoratively, but there's no constraint. The second one essentially says that he will then go through, his team will go through the black box documents, take out the obviously irrelevant material and release them back.
Yes.
Medical records. There will be personal medical records, for example, that sort of thing. They'll go back and they'll retain copies of the others based upon the amended Schedule B, which draws upon the new Schedule C, and subject to one or two tweaks to that, which I accept entirely. I haven't presaged because we didn't work them out until late last night. Subject to that, we are agreed that we proceed with one or other of those options. Our preference is the amendment to Schedule B through Schedule C, and I've got some points to make about the width of Schedule C and some of Mr. Montague-Smith's wording. Subject to that, in principle, in principle we're agreed. It's just a question of whether Your Honour gives the claimant documents which are, on the face of it, manifestly private, which they can then obtain. And in principle, we say they shouldn't have that.
No, well, I don't really think there's an issue about that. If something's discovered to be irrelevant, then it comes back to you. It's as simple as that. But the question is who's going to do the exercise, and I think we're all agreed the most practical way is that he does the exercise.
Your Honour, I wasn't entirely understand. Do forgive me.
No. I think we understand each other. Yeah. But the effect of it, therefore, is that, in essence, I grant both orders, both the second order and the first order, as being the practical way of dealing with it, but all the irrelevant documents will come back to you, and if that isn't plain from the terms of the order sought, that's certainly what I would intend.
Subject to going through the... In a sense, I just want to go through paragraphs 3 to 9, I think they are, but subject only to that. I think we're more...
Well, we can deal with the detail of that in a moment. Yes. So, in a sense, that's
helpful. I think the
fundamental issue that we thought we were here for. We then have Mr. Jones' separate new application that's been made.
Yes, that's right. It was made an hour ago, as I saw it, or at least that's when you received it.
Yes. And I don't quite know how that's going to be dealt with today, but I think we should do our best to grapple with the underlying issue.
Fine.
But much of that depends on what's going on elsewhere, it seems to me. And maybe this needs both instructions being taken on both sides and a frank discussion.
There is some evidence.
But the whole future
yes.
course of what's going to happen here and what's going to happen elsewhere, and what funds need to be released in order for those things to happen, needs to be considered in the round, doesn't it?
Yes, I can see that must be right, ultimately. The difficulty that we face is the way in which this is brought on today. Anyone will remember that this hearing was listed a long way in advance, specifically so that parties could have a long run up to make any applications they wanted to make.
Indeed.
And that's what we did. We issued our application on the 11th of September. And even as late as last Thursday, the defendants filed evidence in response to that application. Sorry, Wednesday, filed evidence in response to that application, saying that it was opposed. So that's what we lined up to argue about today, and that's fallen away in large part. Then what we got, we filed skeletons the following day. We filed skeletons, and the practice in this court is that when you file your skeleton, you have to hand it to the other side. So they saw our skeleton, and then about, I think, 7 hours later, we got their skeleton in the middle of the night. And it was only in that skeleton that we saw that they were seeking to make applications at all of any sort. And they had filed some evidence from Mr. Shah subsequently without directions, which went to the funding issues. But on its face, did not appear to be relevant to the applications that we were making. And then this morning we get this application for a general stay of the search order. Now, maybe, our starting point really was we ought to have had some notice of this. You haven't got any written submissions from me on any of this. We have some evidence which is would in effect be responsive to Mr. Shah's evidence, but Your Honour doesn't have before the court. It may be that there's more that we want to say. So Your Honour may not have before the court all the evidence that you need to deal with this. As you say, it may well depend in part on what's going on elsewhere. And we don't have an in-the-round picture of the funding. Now, I can make submissions on the hoof, as it were, about how we got to this position, the issue in relation to attachment orders in Dubai. We've taken instructions in relation to that. There is evidence in relation to that in Mr. Cross's second witness statement. We do say that at the moment, the assertion that the defendants are struggling with their funding isn't made out on the evidence, and we are sceptical of that. But prima facie, what I say is that the real thrust, the real complaint going forward, the real harm that they say that the funding issue is causing, is in relation to the electronic disclosure exercise that is going on. So it will not affect, for example, the release of the black box documents.
No, that's right.
That's on my group.
And then the next question is to whether and to what extent, if you, and I've got submissions to make on it if we get there, but if your owner accepts that the client is facing the funding problems that it is facing, the next question is, well, how does that affect the way we're dealing with the electronic documents? And your owner will recall that there are two streams of electronic documents that were divided by the search terms. There are those which are responsive, and there are those which are not responsive. And the responsive terms, the responsive documents, the mechanism to be deployed is for the defendants to inspect those documents and flag the ones which they say are privileged and release the ones that are not. So that's the mechanism. So they are at the front end of that exercise. Yes. I can put it like that.
Yes, yes.
Now, as to the non-responsive documents, my primary position at the outset had been that non-responsive documents should simply be released because the search terms were crafted so widely that they are almost certain to catch everything that is privileged. Now, my learned friend was not content with that and raised the prospect then of this further review process. You will remember that, which involves an independent Masons review team.
Yes.
And so the idea is they review in batches, they then release those batches to the defendant's team with a timetable, a deadline, by which the defendant has to then undertake its own checking review. And if the defendants are not happy with that deadline, they come back to court and release it. And so I'll develop this, but perhaps it's for my learned friend to make his application first. But just so you know what my position is for where we go forward today. My position is if we get there on the evidence and so on of funding, firstly, the non-responsive document review should continue anyway.
Well, there's nothing to stop you from continuing with that. His problem is that he says he doesn't have funds for his team to do their bit thereafter.
Yes, and I think that what I would say about that is that the Pinson Masons review team that is in place is a sufficient safeguard. Given what's come before, the effect of imposing the Pinson Masons review team into that, to conduct that review, is effectively identical to Davidson's doing that review, or some other law firm appointed by the defendants. They are independent, they are high quality, well-renowned law firms. So there's no contest about their competence or their integrity. And so it is effectively identical to the defendants just appointing them to undertake the privilege review. So there is no real practical need for a further review. And given where we are, and given the position taken by the defendants as to their resources, it is right, I say, it's just to review that and look at that once more.
Why wasn't I persuaded of that last time, Mr. Moss?
Well, we were in a different position, and I accept that we had this argument previously. And Your Honour's position was a principled one, that they ought to have the last word on it, effectively.
Yes. Well,
and I can see that.
In one sense, it's all slightly back to front, as
yes, I accept that.
One starts, after all, with the defendants having the ability to look at and decide what's privileged, and then having to come to the court if there's an issue about it.
I accept that.
But I know where we are now.
But the proposal was made by my learned friend that this is the way that we would deal with it. It was pragmatic. It was more than we had asked that there be, and Your Honour was persuaded that there should be even more, and that there should be then subsequently a further review by Davidson's. And I accept that we have been over this ground before, but we are in a different place now in terms of what the practicalities are, not just because of the funding situation, but we are here months later, and we still have not seen substantial documentation. And there was an issue right at the outset where my learned friend asked for a general stay of all of this so that he could take a view, his team could take a view. And I think at that stage what was being sought was about 6 weeks, I can't recall, but it was 6 to 8 weeks of a stay. And the point that was made, and never answered, was, well, unless we can start to see these documents, we can't police the order. And so we're in a different position for two reasons. One is the funding point, which is now going to kick this off for some time. And secondly, because so much time has passed, that we either have to get on with it or just abandon hope of really being able to police this order going forward. So that's, I mean, I'll develop that if you'd like me to in due course, but that's my primary position in relation to that part of the disclosure, the documents, electronic document disclosure order. That's my position. Now, I can see that if Your Honour accepts that there are these funding problems, and we'll look at the evidence in due course, and I'll try to persuade you we're not there yet on their evidence, there's more they need to do. But if you accept that, then I can see, in relation to the responsive documents, which are much more likely to contain privileged documentation, then I can see that there is more of a difficulty in relation to that, and that process may need to wait. So I can accept that much if Your Honour is part of the point with the non-responsive documents. Sorry, the other reason why the position is somewhat different now than it was when we first discussed this is because of the extent of the search that has already been undertaken. And Your Honour had our submissions over the summer in relation to the search terms and cut them back to some extent, but there are already hundreds of search terms that have been put through. Not just identifying, as we had anticipated at the time, names of law firms that would be put into those searches, but much broader than that. And in some cases, quite generic terms were included. And as a result, the search has caught hundreds of thousands of documents. And so really the prospect that there are going to be documents in that which are A, not already caught by the search, B, are not caught by Pinson Mason's own independent review, is really very low. And ultimately, yes, I can see that there's a point of principle about who should do that, but principle of that sort has to give way to some extent, at some point, to pragmatism, to proportionality. There is a vast amount of money being spent on this side on coping with the processes that have been implemented as a result of the suggestions that have been made. But the product has been nil to date. And we've just got to get on with it at some point. Otherwise, this is all going to be never ending. Now, this morning.
Sorry, before you go any further,
yes.
The first question, I think from my perspective, is am I going to be able to resolve the question as to whether there is or is not a funding difficulty today?
The answer, I'm not sure I can give you a yes or no answer to that in this sense, because I don't know at this point what more I might want to say on those issues. I think the likelihood is that the evidence that you have from Mr. Cross is likely to be most of what I want to put before you on the funding issue.
This is Cross 2.
Cross 2. I think that is probably right. So I'm not going to tell you today that if you adjourned this for 2 weeks and we came back, I would have some substantially different evidence, because I don't know whether that is the case. There may well be points of detail in particular that I would want to resist. And Your Honour, if Your Honour hears that issue, you may have to hear things from me that I don't have yet in evidence, positions that I know or have been instructed of. But I can make submissions as best I can based on the information I've had. I've had very little. I was in Kazakhstan last week, but I have had a bit of time to look at this, and I can tell you why I say you can be sceptical of these claims. So, in a sense, it's a matter for Your Honour to decide whether this is going to be a safe way in which to decide this particular issue. But I can certainly
I'm just trying to identify the material at this stage.
Yes.
I have the 11th affidavit of Mr. Shah.
Yes.
And that is the essence of the material upon which Mr. Jones relies, as I understand it.
Yes.
And you have Cross 2,
basically. That came before Mr. Shah.
Well, I understand it
Yes.
did, but nonetheless, it's,
Yes.
that's the point.
That's it, yes, quite.
I'm afraid I'm not conscious of having absorbed the Cross 2. Where do I find Cross 2?
You'll find it in bundle 2.
I was looking at this material electronically rather than in hard copy.
Yes, and it's difficult. I've been doing the same. It's precisely the same.
Not too conscious that I've
It's
taken on Cross 2, as I
tab
should have done.
21. and it's really it was a response to something that had been said by Mr. Lyons in his witness statement.
Yes, I've read Lyons, yes.
And so if you turn to page 506, from paragraph 30 onwards, is where Mr. Cross explains what is happening in the Dubai courts and the reasons why that has arisen. And then at paragraphs 52 onwards, he makes various points about the evidence that has been filed, the assertions at that stage that were being made in relation to the funding position of the defendants. But there is no response as such to Mr. Shah's statement or affidavit.
The onshore freezing order,
yes,
and the quote execution of the DIFC freezing order in onshore Dubai has given rise to a fair degree of heat.
Yes.
But I'm not sure at the end of the day impacts on this particular point, because at the end of the day the question is simply, is there available funding or isn't there? So it's the current position one's interested in.
Yeah, I think that's right. I think my learned friend would say something different. He will say that it's all our fault.
Well, I understand.
And that should affect your approach. But I agree with you.
Right.
Yes. I mean, quite significant criticism has been made of my client's position. But unfortunately, the criticisms that have been made have also been made against lawyers. There's a letter...
I've read the letter of the 22nd of September.
Which effectively accuses my solicitors of lying. It fails to take into account what is said in Mr. Cross's witness statement. So, for example, one of the complaints, and allegations are made against me as well, and I don't for a skeleton argument, which are unfortunate, disappointing, and wrong as well. But so you know, there may need to be a chance to respond to some of that, because it's made in open court and it made against professionals, and quite serious allegations are made.
Well,
but beyond that,
I understand all of that, and people may need to say things in order to have them on the record and the like. But for practical purposes, what I'm ultimately concerned with on Mr. Jones's application is where we are. Has he got available funding? Does he need more funding?
Yes.
And if so, what is the right approach to adopt to ensure that he has the funding that's necessary to do what has to be done without delaying this case any more than is absolutely necessary in the process?
Great.
And what I find difficult about all this is the interrelationship with what's going on elsewhere in the world. Because the progress of one can't be seen without reference to the progress of the other. And funding issues no doubt arise in the UK and perhaps, for all I know, in the USA, Malaysia and everywhere else.
Yes.
And I don't quite know what's going on there. But a global approach seems to me to be desirable, and at some point, presumably, you're going to have to decide, and perhaps the parties need to be try to exercise a degree of common sense about it, as to where the substance of this litigation is going to take place.
Yes.
And it seems to me that once that's been resolved, in a sense, the sensible thing would be to merge everything into one set of proceedings.
Yes, absolutely. Subject
regardless of jurisdictional issues that could potentially arise.
I agree.
I agree that requires cooperation between the parties to achieve that. Otherwise, one carries on in each jurisdiction where their jurisdiction has been established. But all that does is increase the expense and delay. That may be to one party's advantage or disadvantage, I know not. But my own strong feeling would be to lean as much as I can on the parties to try and reach an agreement as to where real litigation should take place, involving all those parties that are truly necessary, so the substance can be dealt with.
And I agree. And the bottom line at the moment is I don't know the full position in England. I don't have instructions and I don't have evidence exactly as to what's happening there.
You're not instructed?
I'm not instructed. I've had interactions with the London team.
Is Mr. Jones instructed in the UK?
He is now, as I understand it.
And I will explain a little bit more about what's happened without going into privileged materials, because as your Lordship may recall from July, I hope to be a little bit further forward by now than I am, and I've been candid about that, but I will explain why.
But does that mean that you have, in a sense, a global approach
I do
from your client's perspective?
Yes, I do.
And it's Mr. Shah who is the ultimate beneficial owner here, who ultimately gives the instructions. One way or another, this litigation is going to happen somewhere. And from his perspective, it must be sensible to collapse it all into one jurisdiction, must it?
Without question.
Yes.
Without question, and I can assist the court in a few minutes with some overview material that I have, and I think it will be helpful.
Right. And do you say I can resolve the funding issue today?
Your Honour, yes, you can, insofar as you need to, and that's not a cagey answer, because there's nothing definitive about this. This is a balancing exercise. What the learned friend wants is to press on regardless of our funding, and if that means we're disadvantaged, so be it. I understand that, and I understand SKAT's desire to press on, and I understand the pressure on the legal teams to achieve that desire. But the balancing is that this is a highly complex matter. It's expensive to get a grip of. We can justify what we've spent here in Dubai. We know what's been spent in London, right, in respect to which I don't have sufficient visibility, but for today's purposes I don't need, because it's happened. It is
250,000.
Yeah, and it's gone. Now, whether it should all have gone is a different question, but it's gone, and that we are where we are.
I don't find it hard to understand that. Well, 250,000 in context.
I'm very grateful, because it is an expensive business, and we accept. All we're asking for is not a stay of everything, but a stay of our compliance. Now, that doesn't mean that Pence and Masons
can't get on with what they can get on with.
Correct.
Which doesn't depend on your cooperation, so to speak, or your participation.
Yes. So we've tried to come up. I appreciate it's late in the day, but we are where we are. And I apologise to everybody if that's wrong footage. The other side, it wasn't attended to. We had said in August that if the onshore attachment order couldn't be resolved, we would have no option but to apply to stay. We've repeated that, I think, not another couple of times in September. So the concept of making this application is well understood. And it has been hoped by us throughout the summer, struggling as we have been to understand what was happening onshore. Leave aside for the moment whether we should be told more than told across two, because in a sense, it doesn't, in a sense, doesn't help, other than as part of a discretion exercise, I suppose. But leaving aside whether that was the position, we have now understood what has happened. And I'm going to say, and I'm afraid to say, I will say it robustly, and if it offends people, so be it, that onshore attachment should never have been obtained, and if obtained, should never have been maintained. What it has done is to lock up £1 million of sterling, which should have been available shortly after the 1st of August, and we simply would not be where we are now. And that is a consequence, solely a consequence, of SKAT taking a tactical decision to obtain an onshore attachment order.
Pending the execution of the DIFC order, I understand.
Yes, but what it does is it blocks physically any movement.
I've got that point. So what I want to know is what the current position is. And do you know what the current position is? I.e., is the freeze an onshore supply in identical terms now to the freeze that operates here?
We don't. First of all, we don't know. We don't know. We are told by Mr. Cross that they have won some concession from the onshore court, which they thought the onshore court has been wrong throughout, but I'm not getting involved in that. I simply don't know. But they've won some concession from the onshore court saying that there is now a recognition order, as we understand it. If there's a recognition order of the DIFC freezing order, yes, one would suppose that it's in identical terms.
Subject, therefore, to ordinary business expenditure, legal expenses, and the provisos that we have.
Correct.
Yeah.
But we don't know. We have asked in correspondence, and that's referred to you in the letter of the 22nd. And this may be the key point to come out of that for the purposes of this discussion. We have asked SKAT through principal basis to confirm that the moment that recognition is recognised and the attachment order is lifted, that cash will be available. And they dodged that question and said, we're not entering into further correspondence, that will be a matter for submission. So we have no clarity from them that we won't be in the same position in a week's time. What we do know from Cross 2 is that there is some form of recognition, and that now there has to be acknowledgement by the banks of that recognition, and that acknowledgement does not come back. That's entirely out of our hands. So I have two matters which leave me in a state of complete limbo. One is that I don't actually know what the terms of the recognition are, as I currently stand here. So I'm assuming it replicates your Honour's order, and we've used the word self-policing, but you know what I mean by that, that it is a proper reflection of this court's constraint and not more. And we do not know whether it is agreed between the parties before you that the moment that execution order is effective, that money will be released. And it is key that there are, I do understand, and I'm going to come back in due course to see if we can go through this evidence should it be needed. I don't really understand what is being said by the other side. If they want to say that Shah 11 is false, so be it, and it may well be that if we serve Shah 11 late, then learn friend, of course, can say what he wants to say on instructions, and Your Honour will have to do the best you can. But there are only effectively two sources of funding of which I have any knowledge in respect of debugging. One is the two remaining flats in Limestone House next door. The first of which was sold and gave rise to a bit of a flurry, if you remember, with the DIFC property register and so on. So that was all resolved. The money came through in accordance with the Honour's last order. It reached Davidson's in accordance with that order, and it's been spent in accordance with the freezing order, and they're very satisfied with how that's gone. Limestone 2 and 3, as I've been calling them for short, are on the market. They've been on the market for a long time. They've not attracted buyers. You might imagine, both for this court's reasons and for the reasons of the lawyers involved, we've been placing Mr. Shah under some pressure to take steps to do what's necessary to sell those if it needs to be reduce the price. But I do know this because we've been here before. The moment we reduce the price, we're probably going to be accused of not selling it at fair value. So we have some difficulties here. Mr. Shah is not a free agent in the sale of these flats because he needs to satisfy this court of principal basis and SKAT, which is actually sold them legitimately. So that money is not currently available to us. It will amount to, at best, on the present valuations, £1 million sterling. But I don't personally buy the proposition if they haven't sold after this many months that actually that's going to produce that kind of money. So I don't think it will. But and that assumes they both sell at the same time. The only other money is the onshore attachment money, which is approximately £1 million sterling. And the last time we spoke...
That's added, is it?
Yes. Yes. The last time we addressed this court, we assumed that money would be released. Throughout the summer, we thought that money would be released. We've had, for right or for wrong, and let me just be completely neutral about how it's all happened, we have spent a lot of time and a lot of money and a lot of energy trying to find out why that money was subject to a physical freeze rather than a replication of your Honour's freezing order. We now know why. Park, whether that was good or bad conduct for the moment, it does appear, subject to the reservation in Pinsent Mason's last letter, which I've referenced and don't fully understand, we now appear to have reached the stage where if that money is released, I personally can see no principled reason for Kingston Masons and SKAT to do anything other than do their very best to get it into Davidson's coffers at the earliest opportunity. And if they don't, we'll be coming back to have something very strong to say about it. Now, so what I'm not asking, when we look at this in terms of the stay, I'm not asking this to go on forever. I'm not asking the whole case to come to a juggling halt. I'm asking for a stay of our compliance with the SSO, simply because we can't do it. And this is always very personal, but I will speak personally. You'll forgive the...
Well, you're on spec, I understand.
We're on spec.
Yes.
We've done our best to hold the ring for the defendants and assist this court today. That can't continue. And therefore, I do understand the collateral advantage which will accrue to SKAT if the legal team is starved off the case. Mr. Shaw proceeds as a litigant in person, and the whole case collapses into a black hole almost instantly, and SKAT get complete control. I understand that will suit them very nicely, but actually it's not fair. That's at the end of the day, and if we're to be criticised of the circumstances we find ourselves in, for being procedurally late putting this application before the court, I entirely accept it's not optimal to do it that way, but the application is trailed, and we've done our very best to get it here as soon as we can. May I do one further thing? Can I hand you up a file which will have in it a couple of things that you may find helpful? Malone Friend's got a copy of it. We tried to hand it up beforehand, but rightly handing material up at this stage was a matter for everyone to agree. But it's got a copy of the application notice in it, because formally I'm going to need your permission, I think, to have that.
I've got a copy of the application.
Has your Honour seen a copy of the draft order, which we've served as well?
Unless it was attached to the application, probably not.
It wasn't. It came in subsequently because we got the application first and the draft order. There's a list of what I think are the agenda points for today, which in a sense we're...
Well, do by all means hand it up, Dave, here, so...
Well, I'm very grateful. Thank you. It's also got SHAR 11, which you've seen.
Yes, I've read that.
There's a SHAR 12 in there, which is not relevant. The reason we've...
I've read SHAR 12 too.
Thank you. Forgive us for trying to get some sort of positive advantage from SHAR 12, but it isn't due until we're here today, and we've done it early, and we've done it with the constraints for others. So we are... I've always been concerned in this case, as you want to know, to produce evidence of our engagement with the process. And the reason we have done SHAR 12 in the circumstances we find ourselves is to be able to come here with, we hope, a degree of good faith. That when we say we're stuck for funding, we believe we're stuck for funding, and that's the end. And that's why we've done SHAR 12. There's nothing in SHAR 12 which is relevant. The introductory points, but I'm in your hands as to whether you want to do black box and get rid of it, and then come back to all this, or whether you want to come back to black box at the end, because in a sense it's fairly self-contained. My real concern, as you know, my real focus is survival, not black box. So I'd like to deal with the black box, but it's not my key issue for today.
I'm just looking at your paragraph 2 of your draft order. That on the face of it has no obligation on the defendants to do what is necessary to have the necessary funding. So that won't do in its start form in any event. I said once I'm entirely sympathetic that you should have whatever funds are necessary to defend this matter. But again, I'm troubled by the absence of a global view about this. If one looks at the freezing order that I made, which is in standard form, paragraph 10, you can spend a reasonable sum on legal advice and representation, but before spending, you must tell the applicant's legal representative where the money is to come from. likewise ordinary and proper course of business. And the whole point of that is that the criteria that are set out, I think, originally again in A against B number 2, Robert Goff, I think, many years ago, should be satisfied. Namely, that if you've got available assets elsewhere that aren't covered by the freeze, those should be used before any assets that are covered by the freeze. And that requires one to know what the overall position is. And that's why there's an interrelationship between what's going on here and in the UK. I have no knowledge as to what's caught in the UK and what isn't caught and what other funds there may be. And I suspect the claimants would like to say, if they could, that you had lots of funds that haven't been caught.
Well, but can I help with that?
Yes, please do.
I'll do the best I can. There is one common defendant between London and Dubai, that's EGDL.
Yes.
Only one. London, just to put it in its context, has 96 defendants.
Yes.
Of which 64 are said to be fraud defendants.
64 are connected in some way, loosely, or more directly with Mr. Sharp.
No. Well, they're said to be fraud defendants. The companies.
Well, are they the pension funds?
Yes, but what I call no. The pension fund. I'm going to explain about that if I can. But I have no visibility on what's going on in the States and Malaysia, and we're nothing to do with that. And it's a totally different litigation. And if it insofar as one was looking for a global solution, at the moment that is way beyond my comprehension.
Right.
I think that would be biting off far more than I'm competent.
Well, let's just deal with what I may call the sharp companies, if you can put it in that loose way.
Now, my understanding is that there are 24 SHAR companies live in London. That is to say, 24 companies who have been the subject of representation since the service of the London Order.
Yeah.
So what I'm going to inappropriately refer to as my side, that's really my interest, is 24 companies in London, one common defendant, or 24 defendants in London, I should say. They're not all companies, of course. Mr. and Mrs. Shaw are defendants there.
Yes.
One common company here at EPL, which is on its own, because it's not seated in London.
Yep.
Now, just a word from me. When I spoke to this court in July, I had assumed at that point, perfectly properly, of what I understood, was that I would be fairly swiftly moving into a position where I had proper engagement and oversight of both of those two jurisdictions. That did not occur. Now, before I realised, it was a few weeks before I realised it hadn't occurred, because, as you Honour will know, July passed with 3 hearings, quite a lot of work, and we were really concentrating on what was going on here. London was, using this odd expression, was onboarding the clients, getting started, and considering questions of acknowledgement of service and so on and so forth. And they didn't need me for that, they thought, and I wasn't answered. When we saw some light in the middle of August, I then stood back, looked up to the horizon slightly more than I'd had the opportunity to do beforehand, and realised that what had actually happened was that the two legal teams were operating in effect independently of each other. I'm not being critical of anybody about it, and it's not for me to do, and I'm not trespassing into privileged matters. I'm just explaining why I told Your Honour over the phone in July that I thought I had a plan for the liberation of money, and I have not yet been able to execute that plan. That's the reason. So, even though my fees have run out by mid-August, I nonetheless turned my attention to providing strategic advice as I saw it, which was absolutely essential for the defence moving forward. it may well be the position that that did not achieve a complete and uniform agreement from different parts of the legal team. We required a meeting to resolve that. And still on the spec, we all convened here last weekend in Dubai. As a result of which, it's taken a week to sort it out, as a result of which there will now be a change of solicitor in defending the London...
James will take over.
What is now going to happen, as I anticipated, all I can say to Your Honour is what I genuinely anticipate is going to happen, is that there will now be a core legal team advising what I'm going to call the Shah defendants. That will allow us to make decisions not only about the wording that goes into affidavits and so on. So all that, for the moment, is very important, but it's not strategic. But it will allow us to begin to take a strategic view. I speak bluntly as to my frustration, because I would have liked to have been in the position I stand today about 4 weeks ago. I would have hoped that before the end of August we could have been in that position. And so we've been really constrained not only by the lack of funding, but also by the lack of what I would call a common case management theory to move forward with. There will now be a common case management theory with which to move forward. Your Honour has entirely anticipated that that common case management theory must first grapple with not only all the points which are set out in Shah 11, which are daunting enough for us to catch up with, given that SKAT's been working on those very points for months, if not years. We will have to formulate a case management theory which does not, as it does at the moment, require £2 to be spent on the same case, where one ought to do, because we're doing the same thing in two jurisdictions, at least in part. And there are ways in which we could resolve that. I mean, at the moment, I don't wish to be critical, but I am struggling as to how SKAT can itself justify launching proceedings against the same parties in effectively 3 jurisdictions, and then tell us that we've got to cope with that, and if we haven't got any money to deal with it, I'm finding that, I have to say, a concern. I also wish to flag one point arising from the onshore attachment, which I haven't yet grappled with or got to grips with, but I simply want not anyone to think that it's not on the agenda. The onshore attachment order has only been obtained on the basis that substantive proceedings have been issued in the Dubai court. Now, my understanding is that that may have an effect on this court's jurisdiction. Now,
Well, it could, potentially.
potentially, to what understands the point.
I do. Only 2 were.
Yes, and I don't know what to do about that. It may well be that I could happily reach agreement with the other side as to what we do about that if I can get my money. If I'm being held out for my money, and the only basis upon which I'm being held out for my money is because SKAT may have completely undermined their ability to proceed in this court, then that would give rise to an entirely different dynamic in circumstances where they wish to continue to proceed with all haste to interrogate a search and seize order, which may, as we stand here today, be based on an entirely inappropriate jurisdiction. Now, until such time as I can grapple with that, and I need money to do it, I'm not going to say I've formulated any thoughts about it at all beyond those. But if Your Honour was thinking about one point alone of a jurisprudential nature, which would suggest that no disadvantage should be forthcoming to the defendants as a result of the present position, it would be that. Quite apart from the balance of fairness and justice, and quite apart from how this case can be proportionately managed. So that was a highway and byway, but I didn't want to miss it out. It's a highway and byway, though, which is important in respect of triple jurisdiction. and that is causing cost. And it shouldn't do. Now, I accept entirely that I can't sit back and just whinge about that. We have to engage with SKAT as to whether there are case management solutions to resolve it. And Your Honour may accept from me that I will do so. If there are perfectly proper jurisdictional points in the mix that will advantage my client, then I will be bound to take them, and we may have to come back to that. But if there's a case management solution which sort of suits everybody, then we will be the first to sign up for it. In fact, we may even promote one. And being realistic, the centre of gravity of this entire dispute, so far as the Shah defendants are concerned, and the other, whatever it is, 70 defendants in London, the centre of gravity is in London, not here. That is quite clear. So that's where we've reached. There is a hearing in London on the 12th of October for Mr. Justice Jacobs.
Has he been, lucky man, assigned this case?
I'm not sure it's formal assignment, but I did notice that on, I think it was day 2, it was when he formally adjourned the court early to go and be sworn in. So this was quite a ball to get bowled at you on day -1 of an appointment, I think. That was his position. So whether he's formally assigned, I don't actually know. But I think he is listed to take the hearing on the 12th of October.
Well, can I suggest, in case the court has not crossed your mind, that you should write to the judge in charge of the case first and have a judge allocated who will deal with all interlocutory matters and the case?
Yes.
The good sense of that is obvious, and the court will do it, whether it's Mr. Justice Jacobs or an older hand, I suppose, it's a matter for Mr. Justice Popplewell, who I think is still the judge in charge, isn't he?
But at the end of the day, there's going to have to be a funding solution in London, as well as a funding solution here.
Right.
And my cost project solution is that I've somehow have fashioned 2 legal teams in 2 jurisdictions who don't trip over each other, who can parcel up the work in an efficient way. One of the reasons that needs to happen is that there are 2 reasons that need to happen. First of all, if Mr. Shah and his defendants win this case, then they're entitled to have the case defended as economically and as proportionately as possible. But if SKAT loses and has to pay, they'll be entitled to interrogate what we've spent. So that's further down the line. Much more immediately, if I need to persuade, at the moment, 3 civil courts and at least 3 criminal courts to release money, I'm going to have a credible plan for husbanding that money and spending it wisely. And that's, in a sense, what I floated with Your Honour in July. And that's the project which I thought we would be starting mid to late August, and I'm starting now. That's the 4 weeks that I've missed. But that plan is essential, and that case management essence has now been accepted and will be implemented. But of course, that plan itself requires cash. If we are going credibly to build even a high-level budget without line items, even a high-level budget, and make applications with credible independent support to those minimum 6 jurisdictions, that's going to cost cash in itself. And one of the propositions that I thought about in July, and I still think was the right thing, is that the money, when released, should be released to an independent solicitor who will then release it against budget projections, so that the parties agreeing, or the courts agreeing to that release, can be comforted that it's being properly husbanded. It's not sitting in the defendant's client account, because that may not give the same, without saying anything about it, just on the face of it, the documents may not give the courts the necessary level of comfort. But that's an expensive proposition. So in order for us to give up, we have to have funds in both jurisdictions. Now, I do understand that what's not before the court is a absolutely comprehensive view of everything. But what Your Honour does know is that there are 3 freezing orders, I think 3 criminal restraint orders,
Yes.
and requests for assistance from the Danish government, or from the Danish prosecutor rather, which have themselves led to other layers of blocking and freezing of accounts and assets. Now, in a case like this, it would be extraordinary if SKAT believed everything we said. And starting from where they start, I have no doubt they have a very healthy level of scepticism. But from where Your Honour is standing, which I hope is, in this sense, as objectively as I can hope to stand, what are the sources of funding which I know nothing about, which those 6 jurisdictions have apparently entirely missed? So the starting point, for the credibility of the submissions that I make is that it's highly unlikely, actually, that this great pot of millions out there stands to be secretly used.
Well, I understand, Mr. Jensen. The problem I have is simply this, that the disclosure exercise, if I could put it in that way, is the very thing that SKAT wants in order to find out whether there are a whole lot more of other assets out there that could readily be frozen. Now, what I have to do is to reach a practical solution to all this. I'm about to say, looking at it globally, one would think, leaving aside tactical considerations that either party might wish to bring to bear, and such jurisdictional challenges and threats as you might choose to make, the bottom line of this ought to be that such assets as have been found should be preserved in freezing orders around the world. There should be one piece of litigation that deals with the substance, with everything collapsed into it, all the relevant parties, by which I mean the sharp parties, leaving aside Malaysia, the USA, for the moment. And that one court should then have the global view as to what funds are necessary in order for you to be able to properly defend yourself. And the problem about doing things in 7 jurisdictions is that no one has a very clear idea of what's going on elsewhere, and therefore a global view is not maintained. But in order to get to where I think this case needs to go, and with which I think in broad terms at least, I'm going to have to do something that enables the disclosure exercise to go ahead here. When I say disclosure, I mean disclosure following the search and the rest of it. Which means that you've got to have some funds in order to deal with the privileged position in relation to that. And my inclination would be to release a relatively small amount of funds in the overall context of this dispute, whilst the House has got in order, moving towards a global solution of the kind that I've indicated. That's what I'd like to do. Whether I'm going to be able to do that today is another question. But I'm simply telling you that because that's my basic approach to the matter.
Very good. At the moment, there is nothing Your Honour can do to assist us with funding in circumstances where we can identify funds that wouldn't be caught by something else. So
no.
So
that I understand.
At the moment, we are in that bind. So, in order to persuade all the restraining organs around the world to lift the restraint, I have to have a case management plan and a credible cost liberation project, and I haven't got there and I haven't got the money to do it. In order to get to that stage and to hold the ring on the SSO with the disclosure points, I also need some money.
But can I ask you very bluntly, Mr. How much do you need in order to do the privilege exercise that you think is necessary in relation to the Dubai documents?
Well, That's difficult. Can I update you? Because the figures that I put in my skeleton turned out to be low. We got an email from Deloitte quite late yesterday. All parties did. And the current figures are, I'm going to use round figures because they'll do it. The total's gone up to 10 million and they haven't finished the uploading yet.
Well, that's 10 million budgeted to trial that you're talking about.
Sorry, 10 million documents. So, sorry, forgive me,
I was looking at your 8 figure.
No.
The 10 million.
No.
I wasn't unclear whether that was dollars or what it was. But
I'll come back to the potential budget.
10 million documents.
10 million documents, and the uploading hasn't finished. The uploading won't finish till the end of the month.
Yes.
The entire platform won't be searchable until the 3rd week in October. Of the 10 million documents, there's something between 900 and 1.4 million responsive. The 1.4 is including what they call family documents, so I assume that comes down to 900,000 with some self-evident deduplication, because I haven't interrogated that. So in very broad terms, we're looking at 10 million, of which 9 are non-responsive and 1 million are responsive. Now, this is the position we're then in, but it is perfectly plain that SKAT intends to review those documents in some detail, because they're championing it to get stuck into them. So may I compare this with what would be a conventional disclosure exercise, because this is not one of those. In a conventional disclosure exercise, a party, let's assume it's us, would identify 10 million documents and would then agree search terms with the other side. We would apply the search terms. Positive responses would be put in a disclosure list. Non-positive responses would be discarded. So in a conventional case, no one would read the 9 million because they haven't responded to the search terms. The search terms, of course, would be more than 1 million. But by analogy, it's the same point, because the search terms of a conventional disclosure would be looking at relevance to issues, not just privilege. Here we're in a very different situation. There is no doubt at all, I would respectfully submit, that if SKAT were going to interrogate those documents, then my clients must have the right to do so as well. We can't go into a trial in which they've got documents that they've read, which are actually mine, but the source of the documents for this purpose doesn't matter. Where they've made a judgment, let's assume for the moment, entirely legitimate a litigation judgment, they will rely on some of those documents, but not others. Because they won't be under any disclosure obligation in relation to the lines, they can just pick what they want, because they're my documents. It can't be right for them to do that. And for my defendants to be in a position where they have not got the cash to do the same, because they want to know what it is SKAT have looked at and what conclusions in the round can be drawn from. So that means that we have not a situation of 1 billion documents to interrogate and 10 and 9 to discard. We have 10 to interrogate. Leave aside the privilege issues for the moment. Whether these documents are interrogated now or in 2 years' time, they will have to be looked at. And the cost of that is not insignificant. Now, at one point, I think, when I spoke to the court earlier, probably in July, maybe perhaps it was the late July hearing, I did float the possibility that we had had some success in Chambers with a similar project using junior members of the bar, who reviewed up to 2,000 documents a day. On a 10-hour day. But having made further inquiries, that was simply a first review relevance sift for voluntary disclosure, for a party doing what it could to give proportionate disclosure. That's not this exercise. The exercise we're engaged in here is the perfectly proper and, unless there's some reason to penetrate it, absolute right to protect legal professional privilege. That's the starting point. And the second one is that if SKAT are interrogating all the documents, then so should we. So we have a much more difficult issue than simply doing the first level disclosure review, because if you're looking for privilege, then you might be looking for what type of privilege it is, whose privilege it is. You might have to make some records. And the idea of getting through that in a minute or two is very challenging. However, there is some light at the end of this tunnel. I understand that Mr. Shah owned a magazine. It's got nothing whatever to do with this case. I'm told it's likely that there could be documents in terabytes, whatever that means, but certainly millions of documents in the 10, which could all be magazine documents.
Ironically, it's called equity, is that right?
I was wondering whether I could make a joke about the difficulties of confusing that with privilege review. But let's hope, for example, we can bolt together, now I've taught myself what billion operators are, we can bolt together something that would allow us to take out a good chunk of the 10 million.
Yeah.
Then it starts, so I don't want everyone to be into awe that it's got to be 10 million sheets of paper and 10 million documents which are reviewed. I very much doubt that it will be. And if I've offended everyone else to my left, well, I'll have to repair that offence as best I can. But I would like the opportunity actually to sit down and see if there is a sensible protocol we can both sign up to how that 10 million documents are interrogated. If it's their intention, in fact, to put in a very large team of Vincent Masons to go over them page by page, which is what I believe they're going to be doing, well then, in a sense, we will have to match them. Because I can't go into defending the case without knowing what they've read. It's that simple. So it's going to cost something in 7 figures, I thought, without any doubt at all, to interrogate $10 million. So if one's looking at something less than 2,000 a day, and some estimates are as low as 400 to 600 documents a day, if there's a proper privilege review underway, then it's at best 2 or 3 months' work, possibly 4. You need quite a large team doing it, and the cost could be $1.5 million or more, and that's if they work extremely quick. Now, obviously, in terms of funding, I wouldn't necessarily need that cash right at the beginning, because it's not as if it's all going to be spent in one go. But the difficulty we've got is, however flexible the legal team has been to date, the Dubai team has been to date in running September on stake, that's very different from us taking money out of our own pockets in order to pay a subcontractor to start the privilege review, which is not feasible. So there's also the problem, if one's looking at the amount of money which may get liberated very quickly, we hope, on short Dubai, you can decide how we got here. Let's hope it's liberated quickly. If you'll forgive the expression, there will then be some backfilling in relation to fees earned in September. It's not being done pro bono, it's just being done at risk. So what we really need is to get Limestone 2 and 3 sold, the Abu Dhabi bank money released. That should give us close to £2,000. One has to remember at this point, because I keep forgetting it, that cannot necessarily be exclusively earmarked for legal costs, because there are 3 exceptions to the order. 2 and 14 materiality, as I'm concerned with. One is legal costs and one is business costs.
Yeah, the accountants to pay and the IT people and so on and so forth. Yes, I've got it.
And therefore, we can't simply say, well, there's 2 million coming in, and we'll have all of it. But what I'm trying to say is we are conscious that we need cash to start. That money will also have to fund the cost liberation project, because we can't live on month by month with a small amount of money. And I just want to look slightly further, if I may, further ahead. I don't know if this submission is going to persuade Mr. Justice Jacobs or whoever else it is. But there is a large number of matters which need to be addressed for the purposes of the defence. The first key question, Ron, I'm not sure if you've seen the particulars of claim in London, but it's a full lever arch file, about 420 pages. But SKAT is running a primary case that the law of the torts is English law. So it's a Rome 2 issue. So one might have assumed that the loss was in Denmark. So under Rome 2, Danish law would be the proper law. There are secondary cases, if they're wrong about that, but it's Danish law. Now, none of the defendants can make a call about that sensibly unless they are, at a very high level, able to interrogate Danish legal advice. There will also need to be Danish advice about the nature of the trade and how they sit into Danish law, even if the torts are tried under English law. And I haven't yet worked out precise boundaries between the Danish law matters which will impinge on proper law, Rome 2, and the Danish law matters which will be necessary regardless of which law applies to the tort when it's defended. Given that there's quite a lot to grapple with, and we have the document review exercise as well, I'm certainly going to be making a submission in October that the defences should be submitted in 2019 and not in 2018. And precisely when in 2019 will be a matter of debate. But overwhelmingly, if one is asking me for a global view, I would like there to be sufficient space for us here to liberate cash, use some of that money to backfill, to use some of that money to put the cost project together, which is the full trial cost project. That's the 8-figure cost project. It's going to be a lot more than 10 million. I would have thought the starting point for this case is going to be between 50 and 20. The number of contingencies that will have to be built into that is significant. So I would then want to have to stay in touch with this court and in touch with Mr. Montague-Smith's team, so that whatever money we could then spend here, we could get started on the privilege review. But that will necessarily be not necessarily the guarantee to finish it, because the money that's being released will simply not qualify to be sufficient for everything we need to do. Let me suppose for a moment that Mr. Justice Jacobs does not give us that leeway in England, and we're required to submit a defence in, let's say for the sake of argument, before Christmas in 2018. That will then require me to divert funds to Danish law advice of a very high calibre, covering a very large number of issues. And if I'm constrained here with the privilege review, I won't be able to do that. So, if I may say so respectfully, entirely understand your honest need for an overview, which is what I want. But at the moment, there are too many moving pieces to know exactly how it's going to play out. So my preference would be to persuade you, Your Honour, that I need space on the privilege review, but with an engagement to spend what we can when that money comes in to get it started. And I hope Your Honour knows we've done our best to get our feet to the flames and deliver. When we've asked for space, we have delivered. And then get 6 months, let's say for the sake of argument, through to sometime in the early spring of 2019, in order to try and complete the document review, take all the necessary advice from foreign lawyers and so on, liberate the funds for the case, and draft a defence. And standing from where I am at the moment, if we can do that in 6 months, that will be a phenomenal achievement. But it is the only fair way for us to be required to proceed. That is the burden of my song here and the burden of my song in London. Can we, for the moment, just flip that on its head and see how it sits fairly in relation to SKAT? The purpose of the SSO, Your Honour has the references from textbook attached to I quoted in my skeleton. The purpose of the SSO is to preserve documents from destruction.
Yeah.
Now, I do understand that they've now enhanced that to be a Norwich Pharmacal application, so that it's part and parcel of the tracing exercise. If one stands back from this, if that tracing exercise is to find a pension fund in far-flung Malaysia that they haven't yet identified, is it realistic to suppose that any pension fund in whatever country who was involved in making WHT applications to the Danish state isn't currently aware that freezing orders and search and seize orders have been issued, or that there are proceedings in 1, 2, 3, 4, 5 civil jurisdictions involving nearly 500 defendants? It is really most unlikely. So although SKAT would like to say that they're standing before you here in hot pursuit of the money, actually they're not. It's thoroughly unrealistic of them to think that they are being disadvantaged from delay. I quite understand they want to get on with it, but that has to be balanced with the interests of the defendants. And the defendants in this case have not in the circumstances performed discreditably or badly. In fact, what your Honour will see in the file that I've handed up to you, I think it's tab 4, is a simple recitation, high-level recitation of what we've actually achieved since the last hearing. I don't ask you to study it in any detail, but it's an impressive roster of work. So we don't come here on the basis that every time we're asked to do something, we don't. Every time we promise to do something, we fail, and everything we do is inadequate.
Are you really saying to me that the prospect of finding further relevant documents beyond those that have already been identified, or the prospect of finding further funds which could be frozen, is zilch?
Yeah.
Wherever one goes in the world, you say everybody now knows it will have gone or it won't.
I think the 360, I won't swear to this, but Leonard Friendside probably knows better than me, but I think there are 360 pension fund defendants all around the world in 2 jurisdictions. It really isn't very likely that there's anybody who's completely ignorant about it. And in a sense, if one thinks of what I'm going to call an innocent Norwich Pharmacal situation, court may then be persuaded to give Norwich Pharmacal relief, even though it's an exotic, exorbitant relief, because the claimant wants to be in hot pursuit of the money. But here they haven't done badly in hot pursuit, given the orders they've got and the people that they've currently identified. But they're not after a Norwich Pharmacal order against an uninvolved defendant, an uninvolved respondent, I should say, in that case. They're after a Norwich Pharmacal order against defendants they have chosen to sue and on whom collaterally the court imposes significant burden, perfectly proper, because the court has seen the case before. So they can't have it both ways. At the moment, if we're looking at Norwich Pharmacal territory, my client is not a guilty party, he's an innocent party. He may be a party against whom, for freezing order purposes, there is said to be a good arguable case which one accepted, the court accepted in London. That doesn't make him a guilty party. It makes him a party with an absolute right to defend himself, an absolute right to funds to defend himself, and an absolute right to protect his and possibly others' property. And at the moment, what is proposed is a significant breach of those principles. So what is lined up, therefore, against them? It's accepted, I think, in principle, that they've lost the fight, that they, the litigation team, as Masons, are entitled to interrogate documents which will almost certainly include privileged material. They can't do that. And it's quite clear from what we quoted from G, and it's quite clear from the authorities, my clients have, for practical purposes, an absolute right to protect legal professional privilege. In fact, I was interested to see, as far as G is concerned, conventionally, the SLR is not even entitled to those documents.
Yes, I've never quite understood that.
Well, we didn't.
How does it work? Is the question.
Well, we didn't challenge that because it seemed to me we came in late. That was a technical argument. We haven't taken it, but I've left that in just ironically to show that
I understand.
there is already an inbuilt advantage to SKAT in the way that this order was pragmatically made. And therefore, when my learned friend says, if there is privilege in those materials, we have to deal with it pragmatically. Well, if by that he means that it may well be that privileged material is released to SKAT because my defendants haven't had the proper opportunity to review that material and prevent that happening, I'm afraid that does not address principle. This is not a matter for a balancing discretion between my client's privilege and SKAT's desire to interrogate our papers. It is a requirement for the court to say, I put it as highly as that, but I hope not imperfectly, for the court to say, are the defendants taking their right to protect legal professional privilege? The answer to that is yes, they are. Are they entitled to a reasonable period of time within which to do that? Yes, they are. Have they yet reached that reasonable period of time? No, they have not. Can they do it without funds? No. Have they got the funds? In prospect, yes, but not today. So a reasonable period of time simply cannot be divorced from that step-by-step analysis. And
There is one further question,
right,
which is whether or not the Pinson's independent legal team is an adequate protection in the context of privilege. I'm with you about what the principle is, and it was for that reason earlier the provision was made that Pinson's independent team would do the groundwork, so to speak, and you would have a further opportunity then to look at it. But what's being suggested by Mr. Montague-Smith, and one can see that if Pinson's Masons are both competent and independent with integrity, do you realistically need any more protection? That's, well, I think that what you have to grapple with.
Yes, we do, because in fact, legal professional privilege is, as we know, a difficult animal. There are judgments to be made about what is and what is not legally professionally privileged. And when one is making those judgments, I cannot envision a single case in which a legal team would make that judgment without reference to their own client. St Mason's review team of whatever calibre cannot do that. So whereas the final call on whether it's privileged, because one thinks of it in terms of Part 1 and Part 2 of a disclosure form, they're all disclosable documents for this purpose, but there's a privilege set. The lawyer's going to have the final call on that. I'm not saying the client has the final call, so I don't want to be misunderstood.
The court will have the final call.
Well,
but yes,
no, in the presentation of it.
Yes,
in the presentation. But the lawyer who is grappling with the difficulties of privilege, and there are many here, because it's a question of what privilege, is it transactional privilege, is it privilege relating to private and unrelated matters, personal house conveyancing, fights with your television producer, your television company that wants too much money on the direct debit. There might be all sorts of professional privilege in there which he's entitled to protect. There might be questions of whose privilege it is. We haven't grappled with that yet. That's quite interesting principles will emerge when that point comes out of the woodwork. There's also the question of what I'm going to call the criminal side of the privilege, which has caused difficulties between ourselves and the SOR, which haven't yet been resolved. They'll have to come back for resolution. But I mustn't forget that at the end of the day, because there's a footnote to be resolved there. But not today. And all of those points are going, as far as I can see, the complexity of this case will without question result in matters which you would then wish and need to discuss with your client. Pitts and Masons, however independent in their review team in London, simply will not be able to do that, won't do it. Our clients can be expected to speak to them as their solicitors, and therefore that process must be undertaken by him, because it's his right to protect. And it would be a very unusual proposition if, however good the system we designed on the hoof at that particular meeting, the telephone meeting when I proposed it, however good that system is, it would be an extraordinary situation if the court were to say, in fact, the solicitors acting for your opposition will be the ones that determine how, and if so, to what extent and in what terms your claim to legal professional privilege is maintained. So the starting point for that is thoroughly unsatisfactory. I'm afraid I'm very robust about that. Whether that robustness finds favour with you on is a different question. But I would say unquestionably that cannot be fair. And it won't do for them to say, well, we'll maybe refer back to the Davidson's teams anything we think is a bit marginal. Because again, there's a value judgment in that. And none of us sitting here can assess the quality of the risk of making those value judgments until we've actually looked on the platform and seen the sorts of things that there are there. I'm absolutely without question convinced that there will be privileged material in there which have not turned up on the responses, and that which has turned up on the responses is going to give rise to debate. It will give rise to genuine debate, and it might give rise to some hot debate, but it will give rise to debate for sure. But we have to be entitled to do it. He has appropriately taken professional privilege, and everyone on my side has. That's absolutely right and can't be criticised. And he's entitled absolutely to a reasonable time in which to assess whether a document is or is not privileged before he releases it. And therefore, let's see what progress we can make, because unless I'm going to be given a sore ankle from those who are instructing me, I think it is right to say that we're not trying to stop SKAT from making its start.
No, I understand that. No.
So
all you're seeking is a stay of your obligations.
Yeah. So
until such times you have funds to deal with. Yeah, no, I understand.
Yeah. So they can make their start.
Yeah, no, I understand.
And if we can, if we could reach the stage where the two teams in this court have got sufficient overview of what's going on, and we can talk to each other, and I very much hope that at that stage arrives. If they've made a start, we might actually be able then to have access to the privilege review team in St Mason's in London, for them to talk to us at a generic level about what they've found on the platform and the sort of issues they've come across. So that begins to meet Your Honour's point about, well, can they be trusted to do it? It's not really a question of trust. But I don't see any, while I'm very firm that they can't be given the 100% final task to do it, I don't actually see any reason why we can't try and reach protocols with them for looking at the scope of the exercise, trying to find electronic words which will catch the magazine without catching the word equity, and in some way we can actually produce a sensible way through. That's what I would like to do. And there may come a time when the order says, well, actually you have now had a reasonable time. You've had a lot of money, you've misused it, you've used it on other things, you've chosen not to engage. I'm now going to release these documents because I conclude, the DIFC court, that actually you've had a reasonable time to take your privilege and you haven't taken it. That point hasn't yet arisen. So you hold our feet to the flames as you have on previous occasions that you will require us to engage with. And I'm not sure, for example, I was trying to think what would happen in circumstances where it wasn't a question of a defendant with a legal team staffed at cash, but it was a defendant with no legal team acting as an LIP. And I was trying to think late last night whether there's any pointers that I could derive from that situation which might assist the court. But actually, for the life of me, I couldn't find a solution which the court within itself find satisfactory. The only way, I think, this is an interesting question, the only way I think that could happen would be for the claimant to pay for a lawyer to be appointed, but not their lawyer. It would be an independent lawyer to be appointed
to advise the individual concerned.
Yes. So I think I reached the conclusion that that was the only way around it.
Yes.
So I would like to leave, on this point, I've probably said enough, I think, if we wanted to know where we stand. But I'd like to leave SKAT one challenge. If they want to press on with this, well, they can give us a couple of million quid and we'll keep up with it. It's a fraction of what they're spending around the world. If they're that anxious to keep tabs on some pension fund they haven't yet heard about halfway around the world, they'd give us a couple of million and we'll match them hour for hour. And if they come back and say no, they won't do that, then you want to make where the balance of fairness lies. So that's what I wanted to say, I think, about the overall question of documents. And I've probably said along the way something about each of the other items. I've said what I've said about the onshore attachment, and Your Honour has the point. I do. We may well have offended the opposition, but I don't wish to be misunderstood about it. And court courtesy will prevail. We actually, with the greatest of respect, do not accept that it was objectively proper conduct to take an attachment order in order to fill in a blank because they couldn't replicate Your Honour's order onshore. And it's not objectively proper conduct to, as it were, if you'll forgive the expression, pretend to issue onshore substantive proceedings, which is the only basis upon which they could get that, when they knew at the moment they issued it, they had not the slightest intention of pursuing it. And I just wonder if they had made that clear, which they should have done to the onshore court. Thank you very much for the attachment order. Here's our substantive proceedings to justify it. By the way, we have not the slightest intention of pursuing those proceedings. They're here just for the attachment order. One dresses the circularity of that, and oftentimes with the attachment order without the proceedings, and they justify the proceedings because they need the attachment order. I suspect if they, I would like to think that if they had made that clear to the judge on the shore, they wouldn't have got the attachment order, and it would have been discharged. So I don't wish my courtesy in court to be misunderstood for backing off that point one iota. May I just do this? Because, in fact, when I sit down, other than for black box, I would like to think that I've covered everything I want to say and not spot a point that I haven't, in one way or another, covered. I think I've covered just about everything that I wanted to. Yeah, I think I have. So, I'll come back to black box later or now, depending entirely on how...
Deal with black box tonight.
Separately. So, then I'm very grateful. Can I just check that there's nothing else material that I'm going to sit down? Thank you.
Well, Mr. Montague-Smith, I think you have to decide now whether you want to persuade me that funding is or is not an issue.
Yes. Well, let me tell you, if I may, how we look at the funding issue, because we do say there's scepticism, but it's not just general scepticism arising out of the fact that there's a very strong case for fraud here for a very large number, but there's evidence that these parties have received very large amounts of money. That there are specific reasons why we say funding is to be approached with a degree of scepticism, as it is. I mean, that is not the only issue that my learned friend addressed, and his submissions were wide-ranging. Some of them I've had notice of them, some of them I don't. But can I just say this at the outset? He opened by saying, well, SKAT's position is that this court should just press on regardless of funding. That's simply not my position. I've never said that. I thought I'd made it clear before he started his submissions. My position is that we're sceptical of funding, but if Your Honour accepts that there is a funding problem here, A, it's not our fault, and that is pursued, and various complaints are made against me. But B, if there is a funding problem, then it really bites only on one aspect, or should bite really on one aspect of the obligations that the defendants currently have, which is the documents which were responsive to the search order. To the search terms. Apologise. Okay, just taking a quick step back before I get into the scepticism on funding, or would you like me to dive straight into that? I'm happy to do it either way. But
I think that's the critical point, really.
Yes, all right. In which case, I'll do it that way.
For today's purposes, at least.
Well, you want to say quite a lot about how things are going to pan out, the positions my clients have taken in relation to proceedings, the fact that there are multiple proceedings, there's lots of criticism of multiple proceedings. And then we've got this pretty thinly veiled threat that there's going to be a wrecking application at some point along the way, so that the defendants are aware of that, and they're willing to threaten guerrilla tactics eventually, and maybe they'll take those steps. The position just on that is clearly that until the defendants submit in England, and they've challenged jurisdiction in England, well, they've agreed an extension of time to decide whether they are going to challenge jurisdiction in England. They will, as I understand,
so they still could take jurisdiction points, is what it amounts to.
Yes.
EGDL alone in England has.
I'm so sorry.
EGDL alone with the English defendants.
Yes.
Has reserved its position until it sees the particulars of claim in two jurisdictions.
Yeah.
And we won't get the second particulars of claim until, in theory, the 26th. But friend of mine was talking about whether he's going to be able to meet that, and he may not, he may. But I'm not hugely stressed about the date. But that's an entirely credible one. It's not a challenge to jurisdiction.
There's no challenge out there, but they've reserved the position. And
There's reservation.
But the point is that until they submit, then at common law, the prospects of enforcing anywhere at common law are low. You can see that because the test of common law enforcement of foreign judgment requires submission or presence. And as far as we know, it doesn't appear that they are, so it quotes present in England. Until they accept that England is the right place for this case, then in this court, we're faced with the prospect of having to pursue them in multiple jurisdictions because the assets are in those different jurisdictions. And you've heard why we took the action that we took in the Dubai courts. And I accept my own friend's entitled to take the position that that's an objectionable approach. That is an objection he needs to take in the local courts. I don't think it's a matter for these courts to decide whether that's an appropriate procedure.
No, but there is a discretionary element that could arise there in relation to release of funds that otherwise might have been available if you hadn't taken a step that is said to be illegitimate. That's how the point arises here.
But I hope Your Honour can see why we did that.
Yeah, well, I can see.
And the evidence is that the banks had said they wouldn't feel bound by the order of this court. So the evidence in Mr. Cross's statement is that there has been correspondence with the banks who said we will not be bound. We will not be in breach of any of these court's orders if the defendants in this jurisdiction flout those orders. So the question for us was, do we take further action because we can't, in an unprecedented situation, can't get an order of this court recognised automatically by the DRC courts. I've never experienced that before. None of the law firms involved. The mood may be
generally
changing.
thought to be automatic.
Quite. So the mood may be changing in this jurisdiction, but we have to. The question for us was: do we just rely on the defendants to voluntarily comply with those orders, or do we go ahead and get something which requires them to do so? And this idea of a freezing order being quote self-policing is not one that I, I'm afraid, recognise. The reality of freezing orders is that you serve them on the custodian of the assets, and that's how they get teeth. Because ultimately, particularly when one looks at the contempt jurisdiction in this court and the rather untested nature of it, it's not really going to be of much comfort to my clients.
No comfort if the money has disappeared.
Quite.
and you can imprison someone as long as you like, so to speak, but if you don't get the money,
So while I accept that my learned friend can make that complaint and he can say it's abusive, and that's for him to say, my complaint about the way in which allegations have been made about my clients is not aimed at that. So in the letter that was sent last night, for example, what is said, or the question that is raised is, did Mr. Cross lie when he said that once we got the DIFC court order enforced in Dubai courts, we would apply to discharge the attachment order? And what they clearly hadn't read, perhaps they've read now, was Mr. Cross's explanation that unless and until so the order has been made on shore, but unless until the banks acknowledge that to the courts, then it is not, doesn't create any sort of binding effect on the monies in the accounts. That's in Mr. Cross's statement. That was served well before that letter. Nevertheless, the defendant's solicitors feel it appropriate to write in those sorts of terms to my clients. In addition, they have a crack at Mr. Fortnum, who signed the affidavit. He is accused of telling untruths about whether or not a claim was issued against the first defendant, EGL, in the Dubai courts. That has also been explained in Mr. Cross's witness statement, because what happened was that a claim was filed, but it was a consolidated claim, and the courts came back and said, no, you can't do it that way, you have to issue individual claims in relation to each of those defendants. And again, despite all of this being explained, without any credible engagement with, or any engagement at all with those sorts of assertions, we get this intemperate letter, 13-page letter overnight, in a situation where they're saying funding is a problem, and in the context of an absolutely 11th hour application, which, as you've heard from my little friend, requires me to address you on a wide-ranging number of issues, many of which I don't have full instructions on, and Your Honour doesn't have clear evidence on. And then in my other friend's skeleton argument, albeit in the schedule, he has to go at me for being either in effect sharp or opportunistic. That's effectively what he accuses me of in relation to the lifting of in relation to the 30th of July order, in which Your Honour ordered the release of the black box documents. And that is wholly, I say, appropriate, not only because the order is plain on its terms, but because in Mr. Lyons' witness statement, he picks up on one particular paragraph of my skeleton argument, our skeleton argument, in which we say that the documents will be subject to the SIFT in the usual way, and says, oh, well, actually, that might have been a reference to a relevance SIFT for documents, or a SIFT to decide whether the documents responded to Schedule B. Now, that's an allegation of fact about how he interpreted my skeleton argument. What he doesn't do is show you one of the passage in my skeleton argument that came about 5 paragraphs later, which says, in terms, we think that the documents in the black box will fall within Schedule B, but even if they don't, they should be released to the defendants. So we have a situation where the defendants are saying we're out of money, and yet they're still engaging in litigation in a way which appears to be thoroughly wasteful, and all it's doing is ramping up the temperature. One looks at, for example, the approach to the black box application. So we had that hearing on the 2nd of August, where my learned friend said, well, there was no intention of the 30th of July order to expand the scope of the black box document.
I don't want to cut you short here, Mr. Montague-Smith. I certainly do not attribute any blame at all to yourself. I think your conduct has been absolutely proper and in order in relation to that aspect. I also think the order on its face was clear.
Thank you.
But I also think, and here the fault lies with myself rather than anybody else, that I haven't really picked up on what that effect would be, despite the fact it was clear from that further paragraph in your skeleton. I don't think I had really taken on board the fact that this was going to operate in a slightly different way. And that's why as I indicated at the outset today, and I think I probably indicated in one of those telephone hearings, my inclination was to say, well, the right thing to do is to extend the search terms in such a way as to cover the position.
Yes.
The practical answer is to give you liberty to do what you were going to do in any event, so to speak.
But if I can just make this point, which is that the danger is we look at it in retrospect about,
I know.
with the knowledge of what we now know is in the black box documents, because at the time that we sought that order, and at the time Your Honour made that
Yes,
order,
didn't know.
we didn't know, the defendants did. So the assumption is that a party stores documents about its own transactions, about its own assets, and even if the labels on the boxes say, is our holdings, for example, the chances are that those are documents about relationships between is our holdings and the defendants. So from our side, and with respect from Your Honour's side, it was quite likely that everything in those documents fell within the terms of Schedule B, because Schedule B, as regards the first defendant, is extremely broad.
Yes.
It's all transactions related.
Yeah, absolutely.
So the problem, and I can see that the defendants might have thought, we didn't realise what we were agreeing to. And then it come back to court and said, well, at that time, we did not know actually that the effect of this order was going to be much wider, would be an extension. Instead, what they do is they accuse us of surreptitiously getting an extension of the order. They accuse us of tricking them. It is not, with respect, a helpful approach to this litigation, and it makes matters much more difficult. And in that context,
I exonerate you from any such accusation. So,
all right, well, I won't labour that anymore then. I'm sure I've laboured it far too much, but that's that. But just in terms, just because I was dealing with it briefly, just in terms of how I see, and I don't have instructions on this, how I see the litigation going forward, if the defendants, if some agreement can be reached which is effective in this jurisdiction, then I certainly wouldn't want to see 2 trials, still less 3 trials of the same facts, and one can see that the centre of gravity is London, and if we can arrive at an effective mechanism by which the outcome, or if not that, at least the findings in London are binding in this jurisdiction, but that will require some thought and some engagement.
of course.
So I can see that happening.
But it is to everyone's advantage that should happen, leaving aside any tactical advantages that people may think they can achieve of getting out from under.
Yes, quite. So let me just deal then briefly with the issue of the scepticism as to the funding.
Yes. Can I just say, I think I may need just 2 minutes to read that relevant part of Mr. Cross, the second witness statement again, to make sure I've really got it on board. But would you mind just taking a seat while I do that? Yes, I've read paragraphs 52 to the end, which I think is the relevant point, material. But
Yes.
Is the fact this, Mr. Montague-Jones, that assuming that there are loans which could be called in, assuming Mr. Shah has personal assets that could be called on, are all those in any event frozen by the English order
I think.
on a worldwide freezing injunction?
Well, we don't know, but the main complaint that we have is that we don't have visibility of the income that the first defendant is receiving. That's the main complaint. So it's not so much about the assets. I can't stand here today and point to any particular asset or pot of money that isn't frozen, because if I could, it would be frozen.
But indeed, but as the income comes in, that's frozen.
Well, we don't know, is the answer. And actually,
Well, I mean, it is technically frozen. Whether it's policing as being frozen is another question.
Well,
But it is technically frozen, isn't it?
well, yes, it would be. Yes, technically. And whether it's being policed is another matter. But that's the issue. That there are suggestions, and I can show you why I say this. That there is other income out there. But just to bring back to the start, my learned friend says as well. You know, I may say that Mr. Shah's evidence on this is false, but that is to elevate the test. Because if you come to court and you say, I can't fund this, the burden is on you to give a frank explanation of what your financial situation is. And that has not, we say, happened. And there are reasons to think that there are other sources of income, at least, which are not preventing the defendants from paying certainly their business expenses. And I'll show you why I say that, if I may, just by reference to some of the documents very quickly. The first point is that when we look at the disclosure that was made of assets by the defendants, we were told, and I'm summarising, but I'll take you to it, that there were no substantial assets which were frozen, which were not already subject to some form of attachment order, and therefore locked up. I'll show you that. That's in bundle 2, behind tab 25. Go to page 586, please. I may have the wrong. Sorry? 26. Thank you. 586. Sorry, it's tab 26, 586.
Yes, got it.
Thank you. So this is Elysium Global Dubai. So Elysium Dubai's disclosure of its assets at this time, which was the 23rd of July, so shortly after the freezing order. And you'll see there's bank accounts held by EGDL within the jurisdiction of the UAE are listed. And there are some substantial balances, but then we see at paragraph 3, as previously disclosed, claimants, the bank account held with Adib has been frozen by the central bank since November 2016. So that's the accounts in 2.1.
Yeah.
So it's only 2.2 that's not frozen and is disclosed, and then we get 94,000 dirham. And at paragraph 4, the balances of Emirates MBD foreign currency accounts are less than 10,000 dirham. Then there's disclosure of chattels, but that is it for cash.
Yes.
Now I accept that the evidence from Mr. Shah is that there was a single loan that was called in after this affidavit, which was caught by the attachment. It comes sometime later. So there's £1 million that's brought in, as I understand it, to the MBD account.
Yes.
And so that comes sometime later. And there are actually other loans. There's lots of these other loans, but the defendants say, well, and some of the loans are to co-defendants in the English proceedings, by the way. They say they can't call those in at the moment, or try to call them in, and there's no response. But at the date of giving this information, they're disclosing no available cash, and I think Elysium properties accounts are listed at page 591. And all of the accounts are listed as being nominal.
Yeah.
Right, so they're not saying at that point they can't fund this. And they do fund it. They fund both the business expenses and the legal expenses. And they fund it in part by the sale of the Limestone House property.
Mm.
And that brings in approximately 2.25 million dirham, about £500,000.
Yeah.
But what they say is that they have spent far more than that. And they use the word spent slightly loosely, but what is clear from what they say is that they have spent and paid more than that. If we go back to tab 22,
Yeah.
page 549. This is a letter written in response to some questions sent by my clients. I'll just take you to a few passages of this. So the total amount, so paragraph 1, the total amount spent on legal fees up to August 2018 amounts to 2.7 million dirham. Now, I think what they mean there by spent is not actually paid, they mean incurred, because if you look down at 5b, Your Honour will see legal expenses 1.58 million, so I think that means actually paid. The remaining balances have been attributed to work instructed but not yet paid.
Yeah.
So that's the part of it. And then paragraph 2, the total amount spent in the ordinary proper course of business since 28 July 2018 amounts to about 2.5 million dirham, includes corporate legal fees and so on. So we're looking at about, this is in that period, we're looking at about 1 million a month in expenses, dirham that is. Paragraph 5a, please see below a breakdown of expenses paid from the proceeds of Limestone House unit, expenses in the ordinary and proper course of business, 570,000. So that's come out of the Limestone House property, but that leaves 2.2 million, sorry, about 2 million, apologies, in business expenses, which has been paid, but not explained, which is about 530,000 US dollars. It wasn't there when the freezers went in. It's not explained by the £1 million released in London. It's not explained by Limestone House. But there's $500,000 been spent. Now, this point is made in Mr. Cross's witness statement, at paragraphs 56 to 58. It's on page 511 of this bundle.
Mm.
Mr. Shah has filed his evidence after that. It's 58 is the paragraph. But there's no answer to this point. The other point that Mr. Cross makes, paragraph 63 of his statement, is that you want to see the disclosure about the Emirates MBD account, which had the balance at 94,000, I'm just reminding you. And as Mr. Croft says at bottom of paragraph 63, when we received a letter from Emirates MBD disclosing the balance on the 1st of August, that had increased to 380,589. So there is an increase between the 23rd of July and the 1st of August. In about a week, there's an increase of some 286,000 dirham. So what this indicates to us is that there is a source of income which is not explained, the points made are not answered. And that's to be expected, because we've heard repeatedly through the course of these proceedings that this is a business, there's substantial staff, they need to be paid, and we have this, and we don't know where that money's coming from generally, and then we have this funding gap between what they say they have paid for business expenses and what they have disclosed as receiving. And what we've been told quite recently, I will show you this letter if I may, it's in the final page of Bundle 4, is that the company works exclusively for its parent and for subsidiaries and parties in which Mr. Shah has an interest. So the letter starts at page 1249 in Bundle 4, which is the last document in Bundle 4.
Yeah.
So it's in response to some questions raised about financial matters by my clients, which precedes that. Actually, not immediately, but it's in the bundle. They deal with loans, so the loan facilities that are available, and explain why in each case they can't or haven't been able to realise the repayment of those loans. And then they deal with EGDL on page 1251. So what they say it's an unregulated firm, give the sorts of activities they provide, it provides, and then they say EGDL provides the above activities for the benefit of its parent company, Elysium Global Limited, and the group's subsidiary companies, and all companies in respect to which Mr. Sanjay Shah has an economic interest. Then they say, due to the ongoing global investigations, they haven't been able to appoint an auditor. The last audited accounts therefore refer to the period ending 31 March 2013. Now, what my clients had asked for were financial statements. What financial statements does your business have? Management accounts. The response comes back, no audited accounts. But we know that there are management accounts. We know that from the index that has been served in relation to the black box documents. And those management accounts on the face of the black box index go up to at least March 2017. I'll give you the bundle reference for that. It's quite hard to find on that page, but it's bundle 2, tab 18, page 406.
Up to when? March?
I'm so sorry?
Up to what date?
March 2017.
2017.
Yeah, but there's obviously
Yes.
a procedure of maintaining management accounts. So we asked for financial statements. The answer is no audited reports. In this letter, what is then disclosed is rents at the bottom. Presumably this is for properties, not for Elysium Dubai. Limestone House apartment 1A3 generates annual rent of 140,000 dirham. Limestone House apartment 1F3 generates an annual rent of 220,000 dirham. So that's properties income, it seems to be. That adds up to 360,000 dirham a year, which is about 90,000 US dollars, and by my very rough estimate, maybe up to 100,000 US dollars. But they're not running the business on these rents. And what we have is nothing at all about Elysium Dubai's regular sources of income. So these questions are being asked, they're not being provided, we don't have any bank statements, we don't have any accounts. I would suggest we don't have a frank explanation of where the income is coming from. The points made in witness statements are not responded to. And we've asked for financial statements, and the answer is an evasive, we don't have audited accounts. And it's in that context, when we look at Mr. Shah's statements, that we ask ourselves, Your Honour has to ask yourself, can you rely on what is ultimately an assertion by Mr. Shah when there are these significant gaps? So that is why I say I don't have to show that Mr. Shah's lying. It's not the test. The question is whether or not there has been a frank disclosure of the first offender's financial affairs to this court, and that on investigation that frank disclosure demonstrates that they're out of funds, so they don't have access to funding. And I say they have not met that. That's really all the points that I have to make on that question to justify the scepticism that as I say, my clients have.
Can I just ask you, the paragraph 58 of cross 2,
Yes,
page
sorry.
511,
Thank you.
tab 21,
Paragraph 58, is that? Yeah.
yes,
Yes.
which is essentially the key paragraph, isn't it?
In relation to... yes.
Where does the figure of 1952141 come from?
That comes from the letter,
Right.
which I took Your Honour to, which is at
Page 549?
page 549, thank you.
I couldn't find the figure.
It's
Is it? It's a deduction from.
so it comes at 5b,
5B,
paragraph 5b on page 5.
that's 1580.
Ah, yes. So
As I,
The
which comes
19
earlier.
yes, I see.
We've got 1580 plus
Yes, I'm so
570,
sorry.
which is
Yes.
2.15 that is said to be actually spent,
yes,
right? And then you say the defence don't explain how that balance of business expenses,
yes, sorry.
i.e., and
Yes.
it's that figure that I'm looking for,
Thank you.
from 1.952.
I believe what it is if one looks at paragraph 2, that's the full amount of the business expenses. So paragraph 2 of 549, I'm looking at the letter.
Yes.
So it all comes from the letter.
Oh, 2.523.
Yes, 2523. Subtracting what has been spent out of the limestone house of 570921. I believe that amounts to 1952141. I'm told that it should. Which is approximately $530,000.
Yeah, close enough. Yeah.
I'm told by someone with a calculator that it does. It
Well,
does
it seems to be pretty much there. May not
Yeah.
be. Yes, I see.
So I dare say that if the question was simply, would we consent to the release of a certain amount of that £1 million right now, then the answer probably would be pragmatic, just to push through with what is being said. But that can't happen. The attachments that we have in Dubai are, from our perspective at least, something of a blunt instrument. And one cannot isolate a particular asset that is covered by the order and release that from attachment. It's done by reference to defendants, and so if we were to lift the attachment on that 1 million, we would have to lift all the attachments. It's the only way at the moment that it can be done. Now, once we get to the point where the DIFC order has been recognised, my understanding is that we will be able, those funds will be available for use for legal expenses. My learned friend said he didn't know what our position was on that. That is spelt out in Mr. Cross's second witness statement. It's the final paragraph where he sets out his understanding of that. It's paragraph 64 on page 512.
Yes.
That's our understanding, that the problem will be resolved. But we're not in control of that process. It will happen. But the question for now, seems to me, is whether or not on the basis of the material that's been provided, one genuinely can be satisfied that there has been this frank explanation of the funding position of the defendants, and if so, whether it genuinely is in the position that it says it's in. So, on the basis of what I've shown you, it does look like there are other sources of income which aren't being properly explained. The questions have been raised, the problems have been pointed out, they haven't been answered. You all may want to think about that.
Well, I'm just trying to think of some way of avoiding being back here in another 2 weeks and having the same sort of exercise. I mean, I can understand that you're not willing to commit yourself at this stage, but it seems to me inevitable that there will come a point where you will agree to some release of some funds. And then there'll be an argument about how much it's got to be and how much is really needed, and we'll go through the same exercise that Mr. Jones has been through as to how much he needs, and so on and so forth.
I don't think we'll, well, I would hope that we will take a constructive approach.
Otherwise, we're going to be here again in however many weeks' time it may be, where I require Mr. Jones to come forward with better evidence on the basis of what you say are the gaps in his evidence, and we have a full argument about whether or not they can fund it, whether there are other hidden assets, and so on and so forth.
Yes, all right.
Now, that's a possibility, of course, but it simply means that we're going to be another 4 weeks down the line without anything very much being achieved.
I can understand the sentiment, and I can understand Your Honour wishing to take a pragmatic approach to these sorts of things, but there must be a quid pro quo to that. It must affect the way in which Your Honour approaches, I would say, what to do if there is a funding problem. We move on to that. Because it can't be right, it seems to me, for the defendants to say, well, we've got this funding problem. Well, what's the answer to these questions? Don't worry about that. We've got this funding problem. You can believe me, it's a problem. And the result of that is all of our obligations need to cease. Now, I can see that it bites, as I've said at the outset, I can see that the sort of problem they complain about bites more directly in relation to the documents which are responsive to the search. But having spent all of that time and energy in devising those search terms, And in imposing a team which ultimately was selected by my learned friend, can it really be right that we should carry on with that process and they should have no obligation to engage in the way that the court originally anticipated? So if Your Honour is not happy to draw a halt to this now on the basis that the evidence is inadequate, then what I would urge you to do is to allow that to colour the way in which you look at those subsidiary issues and how you deal with, in particular, the question of the documents which are not responsive to the search. There's a whole other issue my own friend raises. He raises it in the skeleton argument. He raised it some time ago but didn't press the point. But his suggestion appears to be that we need a relevance review of all of the electronic documents as part of the process that we're about to embark on. And it must be right that if we're going to do a disclosure exercise for 10 million documents at this stage, it is going to be extremely expensive, it's going to take a long time, and my clients are not going to see documents for a very, very, very long time. But that, if we take that approach, we're back to the position of devising search terms again, which was an entire process that we've been through, with the sole purpose to try to cut short the privilege exercise in relation to the non-responsive documents, so that we can get those documents out. All issues of relevant searches and all the rest can come later, and if necessary, my own friend reminds my clients, Prince Masons, in the skeleton arguments, that if my clients, solicitor clients, come across documents which are irrelevant, then they will not be passed to their client. And that's fine, I can accept that. My Prince Masons are duly reminded. If necessary, there can be a direction in precisely those terms to catch that sort of part of the exercise at this stage. We can park all issues of disclosure of 10 million documents until later on down the line. But ultimately, one has to look then at what... So we're moving on the basis that there is this funding problem, or at least we're trying to solve the funding problem that there may be. Fundamentally, my problem is with the other half of it, which is how... So not the responsive documents, the non-responsive documents. Your Honour asked the question, well, what additional need is there for a further Davidson review after Pinson Masons? And the answer that came back was essentially that it's not an objective. It requires a certain amount of judgment in order to assess whether or not a document is privileged. But that's always true. And if one takes a step back and realises that actually, and fully takes on board the fact that the Pinson Masons team is independent in that respect, we're not allowed to have any communication with them. They can call for assistance from their client, from my opponent's client if they need it, in making their own independent judgment. They can't take instructions from the first defendant in undertaking their review, but that would be inappropriate anyway when a solicitor was undertaking that sort of review, even if that was their client. The client gave them those sorts of instructions, you must say that this document is privileged. Then they would have to either have those...
Yes, which you might inquire the client as to the purpose for which something was created, and so on and so forth.
Those inquiries can be made. Two things. Firstly, those inquiries can be made, and it doesn't involve Davidson's, because those inquiries can be copied to Davidson's, but if needs be, that sort of question can be asked directly to the first defendant. Why not? And then secondly, even if there was that problem in relation to that subcategory of documents, it shouldn't drive the way in which the court approaches the rest of the documents. There are, we're told now, 10 million documents. I haven't seen over 10, but there are 10 million documents, of which 9 million will not be responsive to searches. And we hope, we expect, that almost all the privileged documents will be reviewed, but will be removed. But a direction to the Pinson Masons team that, in case of doubt, they should hive off those documents will solve that problem with a stroke, if that's what's needed. The concern from my client's side is not to create a disadvantage or to take advantage of a difficult situation the defendants are in. The concern is that we are 3 months since the search order and we still haven't had substantial documents. Now, my learned friend makes a submission, oh well, it's too late now anyway, the cat's out of the bag, and because there has been this delay, anyone you might want to chase for assets, it's all long gone. Firstly, that's, I suggest, a deeply unattractive submission, particularly when, in large part, quite a substantial part of that delay has been caused by the litigation strategy of the defendants. When we look at the black box documents, they now concede, ultimately, an application which really was ultimately their application to restrict the 30th of July order. We've had 2.5 months delay in release of the black box documents as a result. And I'll take you to when we deal with the black box documents, I'll explain a little bit about what we understand to include. But there appears to be no doubt that they include about 55 boxes of information about WHT applications and the pension funds who made those applications. And there are parties who we do not recognise listed amongst those boxes. And that's used against you to say, well, you shouldn't be able to have those. You shouldn't have Is Our Holdings box, for example. But what I say about that is it's very likely that in those boxes we're going to find documents that are relevant to the WHT application and to the fraud generally, or to the location of assets. And so for my learned friend to rely on delay in getting documents out as effectively annulling the purpose of getting the order is, in my submission, very unattractive. But also it just doesn't answer the point about policing the search order itself, which is about the need to identify other sources of documentation and make sure that the integrity of the documents that we do have is complete.
And are you able to tell me how far the Pinson's independent team have got thus far?
As I understand it, they've been instructed for some time, 2 weeks, is that right? I think 2 weeks they've been instructed. They've largely spent that time, I believe, I don't know, so I have access, but I believe reading in, getting on top of material. And they have started their review. They've done 1 day of review thus far, I think. So that's all I have for you today. And I don't know, they've selected a particular batch.
Yeah.
Yeah.
And when do they expect to be in a position to say we've reviewed this batch?
I don't know.
And we would now, under the terms of the order as it currently stands, be submitting those documents to the defendant's team for their further.
I don't have any reliable information about that because I didn't know that it was going to be an issue today. But the estimate from behind me is about 3 days. But that is, I wouldn't place too much weight on that. Yes, so it's a batch of 18,000 documents out of the millions that there are. What happened was that my clients wrote an open letter to the Pinson Masons review team, making suggestions, no more than that, as to how the team might wish to approach the documentation. And so amongst those suggestions was that it might want to try to find the intersection between those documents likely to be non-privileged and those documents likely to be relevant to the purposes that we were seeking. So to aim for financial documents, bank statements and that sort of thing in the first instance. But I just don't have reliable information about when the first batch is likely to be coming out. The result of the current mechanism, as you can see, is that if we stay the obligations of the defendants in relation to that, we'll get to the end of that batch, hopefully in a few days, and then there will just be the documents will get stuck in the system. When one looks at what that review is intended to achieve, it's really very much late in the process. It's intended to be sort of the third fail-safe, the defendant's review. So the first fail-safe, the first check was the search terms, the second check is the Pinson Masons team, The third check is the defendant's review of the Pinson Mason's work. So it's very much not, I would suggest, intended to be a full-scale page turn of 10 million documents. It's intended to be a light review of what has come before at that stage. And so when one couples that with the observations I make about undisclosed income, the first defendant, access to funding likely to be, one just has to step back and say, well, is it really likely that when the Pinson Masons review team releases those 20,000 documents and says you've got 4 days to review them, the defendant's not going to be able to fund that? Has that been established?
Yes.
I think that's all I really had to say about the issues of whether there's a funding problem, if there is, the extent to which it affects us. Obviously, my position is that it shouldn't affect the way in which the black box documents are dealt with.
Yes.
So whatever mechanism there is to deal with those documents shouldn't require the further imposition of review by the defendant's team. They've reviewed it for privilege, so privilege is off the table.
Yes, correct.
The only question is then relevance.
Yes.
Yeah.
Yes.
So that's all I had to say on those issues. There's obviously the case, the issue of the black box documents themselves.
Well, we'll come back to that.
We can come back to that.
Yes.
Thank you.
All right. Thank you. Mr. James, is there anything else you want to say about this range of issues?
Well, no, I just wanted to. I'd have to take instructions on the detailed points that Learned Friends stated about funding. But this is not an application for the release of funds. This is not an application for the lifting of the freezing order. He says there's a burden on me to have the nth degree of being full and frank. In fact, with the great respect, you're wrong. This is a case management question as to whether in the circumstances you are satisfied that we have the funds available, circumstances where we're all on spec, so we must be being had big time, whether you're satisfied that we've got the funding to start reviewing, whether it's 1 million documents or 10 million, let's just stick with the 1 million for the moment, whether you believe that we have the ability to do that. I would respect you submit to Honour that you must be satisfied that whatever wrinkles Learned Friends looking at, we don't have that money. But there's a couple of other points I'd like to make. Language is a subtle thing. So what Learned Friends says is that they can't help us with the onshore attachment order at the moment because it's all or nothing. But he started that by saying they have some sympathy and they could consider the release of certain amounts of the £1 million held onshore. But they can't do that because it's all or nothing. Certain amounts was the expression used. It's not a question of certain amounts. There is no doubt of any kind whatsoever that the defendants will need the entirety of the £1 million held onshore, and it will be spent and spent legitimately. And one must be very careful. I go back to what I said when I was arguing against extensions of proprietary orders in July. Freezing orders do not provide this claimant with the ability to interrogate what the defence legal team says it needs to spend. All they're entitled to know is the source of the funding for the legal expenditure that's being spent. That's all. And they exceed their powers and the authority that the order gives them when they seek to impose constraints and to interrogate what we're spending and what we're spending it on. So that's what I want to say about that. On the question of the suggested compromise, in other words, that Your Honour should now permit this all to go ahead and if we can't keep up, we can't keep up, and whatever gets released at Pinson Masons Birmingham is released. But just pause and investigate that for a moment. I want to look at the problems that are going to be caused either here or in London when that happens. Let's suppose Pinson Masons London review team completely honestly makes a mistake and releases a privileged document. That'll be reviewed by Pinson Masons Birmingham. What are they going to do? It's not being reviewed by us. It's not therefore a question of if my team has left a document to go through, then they can say, well, we've waited, we had our chance. So are they going to come back and say, actually, there's a train of inquiry here because there must be another document for which you've claimed privilege? We don't see that. And then the judge has got to unravel how that has happened.
Yeah.
But that can't be right, because unless they're going to undertake, let's just test this, unless SKAT will undertake not to make any use at all of any privileged document that gets through to them by mistake, and I hazard they won't, then you want us creating a problem. What if, for example, they've already said that they wish, in due course, to reserve their rights to maintain an application to penetrate legal professional privilege on the grounds of iniquity. Now, that didn't come as a surprise to me, it didn't come as a surprise to I'm not sure, and there are certain ways in which they're entitled to do that. This will hand them, potentially, an advantage. What happens if they found an iniquity challenge in due course based on something that their own firm, SKAT's own firm, has extracted from these documents, with my clients having been told they don't have the opportunity to review their own documents, to take their own privilege? So I just leave that thought with the court, because I think Mr. Montague-Smith was saying I didn't have much to say about his suggestion that Pinson Masons London should do it for us. But it's a thoroughly bad idea. In a sense, if one's argument to something is strong, one doesn't have to have 14 arguments to back it up. It's just really that it's different facets of the same thing. They've also said they're 3 months down the line and they haven't yet been able to make a start. Now, I will accept, and it's on me, I'm very sorry, that I took a principled objection to the rewriting or construction of paragraph 30 in circumstances where it's clear from the correspondence that we had never intended that to happen. Now, I don't wish to go back over that ground. But I said on the day I'm taking a principled objection because it's not a question of whether they might get them in due course or whether I could find an objection. The principle I took was that they weren't entitled to do more than the order permitted them. Now, my learned friend described that as a litigating tactic. It wasn't. There was no tactical point there. I wasn't trying to hold them out from seeing the documents for a period of time. I had no tactical purpose in saying it. I took a principled objection. Now, I've waived that principled objection for entirely pragmatic reasons. It doesn't make it wrong. Secondly, they say they've been held out 3 months down the line. But 3 months down the line, we're now, they got their, well, in fact, it's not 3 months down the line because they didn't get their order until the 27th of June and they didn't serve it until some days later. What we know is that on the first occasion where the privileged review team could start looking at these documents was yesterday or today, which is when they could have started looking at them if they weren't the privileged review team. So they haven't been held out for 3 months. It's taken 3 months to acquire it, load it onto the platform and start reviewing it. It's just a bad point. There's one other thing I want to ask. Through Your Honour, I wonder if Pinson Masons in Dubai know the answer. When Pinson Masons started saying, this is now, we're getting our review team, we will give you the documents to review when they come out of the review team, and we expect you, Davidsons, we expect you to review at a rate of 10,000 a day. Now, we've just been told that they've started a batch of 18,000, which they intend to get through in 4 days. So who's being fair here? And how many are there in their review team? I wonder if we could have that information so that Your Honour might gain some assistance as to the scale of what we're up against. Because if they say they can review 18,000 in 4 days with X people, we'll be able to test that. Do we know the answer?
I don't know the answer because none of this is. But I mean, all right, the question's being asked. I'm told the review team has 6 or 7 people in it, but they're not working on it all the time. I can't possibly give you the number of hours that have been attributed to it up to now.
Well, I didn't press that further. It was just a genuine idea. And I'd actually like genuinely to know how easy they found it.
They've got the names.
And if they can get through it more quickly than I fear, then I have to promise you I will be the first to applaud that. I'm not trying to make a difficult scheme. I'd genuinely like to know how easy they get to find. So that's what I want to say. There are all sorts of tiny points, but essentially that's the
Thank you.
Can I just say one thing in response to the request
Yes,
for an undertaking, which is that I'm not in a position to give an undertaking. I doubt that would be a problem. The point that's being made is what happens if Pinson Mason's review team makes a mistake in the document. That's a problem that arises in every case. It would arise if Davidson undertook the review.
Yes, documents handed over by mistake, yes.
And all the lawyers, there's well-travelled rules about what lawyers do if mistakenly identified, disclosed privileged documents. They have to hand them back, they can't act on them, they can't read them. It's happened to, I would imagine, most lawyers at one stage. They've received something they shouldn't have, they send it back and delete the email. Certainly happened to me.
I hope not most lawyers, but it does happen from time to time.
Well, it's happened to quite a few people. I mean, it's not an unusual event. But the point
task
is,
has got increasingly difficult, no question
no,
about it.
quite. But the point is that lawyers know how to deal with those
Yes.
situations. Thank you.
Thank you. Putting to one side the question of the black box documents for the moment, which will be the subject of an order which I understand will be largely agreed in its terms, the details of which fall to be discussed, because the privilege review in respect of those documents has already been carried out by Davidson's. I'm now faced with what is on any view an 11th hour application made by the defendants seeking a stay of the performance of their obligations in relation to sifting for privilege until such time as funding has been obtained for them to effect that task. There is also a wider aspect of funding which has been referred to by Mr. Jones, which is the need for much more substantial funding in order to deal with questions of defence and the like. He's talked of very considerable figures in that regard. The position, so far as that is concerned, is unsatisfactory because I do not consider that I have adequate evidence about the funding difficulties to be able to form a considered view. Mr. Montague-Smith has pointed to inadequacies in the material put forward, particularly by reference to the second witness statement of Mr. Cross and the correspondence upon which that is largely based, including a letter of the 9th of September from Davidson and Co. It appears to me that those points are well made. Mr. Jones is not in a position to deal with them, and that is not entirely explained because he has had the opportunity of putting in a witness statement from Mr. Shah at a late stage, has made an application at a late stage in the light of this second witness statement, which is dated the 19th of September. It is all very unsatisfactory that all this should come about at the last moment. The position generally is that time has moved on with very little overall progress so far as the claimant is concerned in seeing documents that are responsive to the search. But there are issues of principle with regard both to the nature of the order made and the question of privilege. But cutting to the chase, to use the jargon currently popular. The view I've taken is this, that there can be no stay of the defendant's obligations with regard to the orders already made in relation to sifting for privilege, unless there is proper satisfactory evidence about inability to fund. I cannot be satisfied that £1 million or more is required for the future conduct of the business. That cannot be found from sources available to the defendants at this stage. Dealing then with where that leaves us, it is of course open to the defendant to produce such evidence and to seek release of funds which are the subject of freezing orders in order to run their defence and for ordinary business expenditure. There are provisions in the existing freezing order in paragraph 10 about use of frozen funds for those purposes, with notification to the claimants of the source of those funds. As matters stand with regard to the funds frozen in onshore Dubai, I am informed that there is no way that currently the claimant can agree to release part, but it is said that once the DIFC order has been recognised in Dubai, then that should be possible. Dealing first with the issue of the non-responsive documents, of which there are said to be some 9 million or so, the current position is that Pinson's independent team, who are reviewing those documents for privilege, have carried out a day or so of review and expect to finish a batch sometime within the next few days. I take the view that it would be wrong in principle for the defendants to be deprived of the opportunity of reviewing those documents themselves following Pinson's independent team's decision. They should be given adequate time for that to take place. In that context, Pinson's independent team should spell out, as previously indicated, the time in which it could probably be expected that Davidson's should review those documents, indicating the time it itself has spent and the number of persons involved. If then there is no response from Davidson's or those instructed by the defendants, then it will be open to the claimants to come before the court and to say that adequate opportunity has been given, and that at that stage the defendants, having failed to avail themselves of the opportunity to sift for privilege, the Pinson's independent team's decision should be taken as definitive and the balance of documents released. That can happen on a batch-by-batch basis. In reality, this means that nothing is likely to arise for at least a matter of a week or more, which would enable the defendants to get their house in order in relation to the funding issues about which concern has been expressed and about which I am not yet satisfied. It is very unfortunate, to my way of thinking, that this hearing, which was arranged with a view to ironing out what one perceived as major problems in the context of the future conduct of the case, has not given rise to the possibility of so doing, then that there will inevitably be a future hearing at which such matters have to be dealt with if they are not the subject of agreement. I should make it plain also that Pinson's independent team should inevitably give an equivalent time for the response from Davidson's as they themselves have taken, with some latitude because of the lesser facilities available to Davidson's to deal with the review. I should make it plain too that Pinson's independent team, in case it was not plain before, have the ability to ask the defendants and or the defendants' solicitors questions in relation to the particular documents in order to come to a view as to privilege. It is therefore inevitable, it seems to me, that absent agreement the parties will come back before the court. Whilst not making an order, I express the view that in any event there is room for the claimant agreeing to release some £250,000 of funds once they're able to do so from the funding that from the assets frozen in onshore Dubai on the recognition of the DIFC order. It seems to me that a sum of that sort is what I would envisage being released simply to oil the wheels and get this process moving. I'm unclear how speedily an application that deals with the overall funding requirement can be put together. And I'm particularly conscious, as I have already expressed it, that these matters should be considered in the round, globally, in the context of litigation that's taken place in the commercial court in England as well. I have already indicated in the course of discussion with counsel that it appears to me self-evident that the substantive matters that are in dispute should be the subject of litigation in one jurisdiction only, and that the findings there should be binding in one way or another on all the relevant parties that form part of what I may loosely call the Mr. Shah's empire. To collapse the proceedings into the multiple proceedings into one set of proceedings would seem to make obvious sense, and the taking of tactical steps by one side or another does not advance matters further in the context of ultimate resolution of the dispute, and simply leads to increased cost, delay, and work all round. No court will be pleased with that, and I anticipate that the commercial court in London would be likely to take a similar view. We'll deal with the black box documents in a moment, but I think that is as far as matters can be taken for the moment. It being open, as I say, to either party to come back before the court. But I emphasise it must be on the basis of adequate evidence so the court can determine the matter one way or the other.
Ron, may I just, I'm sorry, before we get to black box, may I just ask you, procedurally, would you be prepared to adjourn over the stay application so that we don't have to receive a fresh application notice?
Subject to any cost issues that may arise.
I entirely understand that, and that your decision today is your decision. I'm just trying to find an easy way to come back.
I can't think of any reason why it would be necessary to issue a fresh application as long as it's understood the basis upon which I've made my decision today.
The problem then comes as to when and who serves evidence. That's the only issue.
Well, I understand that, but it's going to be Mr. James's burden to produce evidence to say he's got a funding difficulty and wants either to be released from his obligations
Yes.
in the sifting process for privilege, or seeking the release of particular funds. And the other way it will arise, as I say, is if he says, I want to use these funds, and indicates where it comes from, and you object to say, no, you can't because we're not satisfied that you haven't got other funds available elsewhere. But either way, it then comes back before the court with proper evidence from either side. And I would not be at all pleased were I to receive last-minute affidavits on the night before one. It's a matter that needs to be dealt with properly, with witness statements from both sides and skeletons that put in on the basis of the evidence that each side has adduced.
Yes.
And I'm fairly tolerant generally about such things, but I shan't be tolerant in the future.
Message received. Thank you.
Shall we turn to the black box?
If we may, yes. So in relation to that, I think it's accepted that my client should undertake the review of black box documents in the first instance.
Yes.
It's accepted that that doesn't need to have any involvement from the defendants. So there doesn't need to be a process which involves the defendants. That was part and parcel of our alternative mechanism, if I can put it like that. So really the issue is how we go about this. And for pragmatic reasons, our primary position is that we should simply go back to where we were before, which was the 30th of July order. I'll show you that in a moment. Subject perhaps to the imposition of a further order or direction requiring Kinston Masons to return any documents.
Any irrelevant documents.
Irrelevant documents. Irrelevant either to... But the question then is irrelevant to what? And we would say irrelevant to these proceedings, irrelevant to the proceedings in the UK or in Dubai. It may make no difference, but ideally it would be irrelevant to those proceedings.
Well, it's irrelevant to Tracy, putting it basically, isn't it?
Well, not quite, because it turns out, as we'll see in the pleadings, that actually the claim against Elysium Global is a bit more fundamental than simply handling the stolen money. So the involvement of Elysium Global appears to have been rather more central to the scheme itself.
Look, I understood Mr. James to be accepting that effectively this is advanced disclosure for the substance of the action.
Yes.
I think I'm right in saying that. And so the order covers that. So, subject to particular points that Mr. James wants to make, it seems to me that there should be both an order extending the search and there should be an order that follows the 30th, or repeats the 30th of July order with the variation that you suggested about return of the documents that are irrelevant to the substance of the dispute.
Yes, all the location of assets, so tracing or...
Yes, exactly.
But even enforcement, not just tracing. Because we would say that on a Chabra basis, we would...
Yes, it is.
Yes.
Yes, and I think Mr. James accepts that too.
So the mechanism that we had devised in our alternative order goes to the lengths of trying to list out all of the parties who are parties to all of the global actions. And I think that is an attempt to reproduce what Your Honour has just described. So my strong preference would be to have a form of words along the lines, literally along the lines that Your Honour has suggested, rather than have an attempt to reformulate the order by reference to named parties. Because that list is going to be very long and in practice going to be very, very difficult to deal with. If one has a list of 600 parties and the lawyer has to go through the documents checking whether or not that document contains information about a transaction with any one of those parties.
Well,
then,
I'm envisaging two separate orders
yes.
that effectively do the two different things that you had as alternatives. They're cumulative,
Yes.
in other words. So we're extending the search terms,
Yes.
and we're also making an order
I see.
that follows the first line that you were suggesting.
Correct.
Because that's a pragmatic solution in the context which Mr. James accepts as being pragmatic. But it seems to me it covers the ground then, both as a matter of principle,
Yes.
which
I
Mr.
see.
James is rightly concerned
I
about,
understand.
but also gives us a sensible, practical way forward that isn't subject to the same problems that could potentially arise were we simply to go down the first route.
Understood.
I
I apologise, I hadn't completely
No,
understood
I
what the
probably
suggestion was. No, it was my
I
fault.
probably hadn't expressed that clearly.
No,
That's
you're
what I
fine.
had in mind from my reading last night.
Too much time on aeroplanes, I think, for me. But I think that is therefore what I'm asking for, even on paper. So,
Well, let me hear the
Best
refinements
thing
that Mr. James has in mind.
Well, could we just look at the paragraphs 3 to 9 of the proposed order? It's in tab 3.
Tab
3, volume 1.
Yes, thank you.
So there's 2 documents we'll need to look at just to look at these. I just wanted to indicate, if I may, one at a time where I've got agreement and refinements.
Just bear with me a moment because I've been working off my own separate bundles that I've compiled elsewhere. So, I see it's 1 o'clock. I take it that people would rather we try to knock this on the head now rather than break.
I probably by the time what you Smith's replied, it's probably going to take 15 or 20 minutes.
Well, is there some benefit then in taking the break and you having a word with one another during that time?
Of course.
And then we may be able to short-circuit things slightly too.
could I just clarify one point, which is that my learned friend's taking into these provisions of the order, which are mechanical, and so dealing in effect with the practicalities of the release of the documents, which I had understood Your Honour to be indicating ought to just be going away, and ultimately we're just effectively amending the Schedule B to the order, the search order, in terms that appear on page 12 of the bundle. So in effect, paragraph 2 will be the order which Your Honour makes, plus the return of relevant documents, plus then an amendment to the search order in the terms of Schedule B as going forward. My learned friend is about to take you to paragraphs 3 to 6 and so on, which really deal with the mechanics, which are swept up and unnecessary if Your Honour makes the order in terms of paragraph 2. So it may be that the misunderstanding of Your Honour's indication is also a misunderstanding from the other side,
well,
and there is a principal question about practicalities as well.
I didn't entirely understand, and I think it must absolutely be me, but I didn't entirely understand what it was heading for. But you did say an order in the terms of both of the orders proposed. So both of the orders proposed in the alternative paragraph 2. So if that was the way we were going, I have got concerns about the width of paragraph 2 and the mechanics under paragraph 2. They're not large and they could be easily resolved. But I did want to go through those because if in fact you think those concerns are proper concerns, that may cause the court to revisit which order it makes. But I had understood you to say that you would order both of those.
They're mutually inconsistent is the problem I'm having with that.
I'm either losing my grip or the will to live, I'm not sure which. But where is all the material relating to the
list of individuals?
it's the Schedule B, that's what I was
So, yes. So,
what I really had in mind was the width of Schedule B. I wanted that extended. That was my point. In terms of the practical way of dealing with it, it is indeed the manner that was originally suggested in the
paragraph 2.
Paragraph 2, the 30th of July.
Yes.
But as a matter of principle, it seems to me that one ought to extend the width of the search.
Yes. As a fallback in a sense, just to cover the fact that...
To do the thing right as a matter of principle,
yes,
whilst accepting that your paragraph 2 is the practical way of dealing with it, which means that effectively paragraphs 3 to 9 onwards don't have any impact at all.
Yes.
Oh, I'm sorry, I entirely misunderstood.
No, well, it's probably I didn't express it very clearly, Mr. Jones.
Yes.
That's what I had in mind. Would you like to have a think about that and see if you can reach some sort of accommodation on it? What time would you like to restart? 2 o'clock?
Yes.
2 o'clock. And I'll have a look at it over lunch and
Well, I
clarify my own thinking.
Certainly, if you're going to have a think about it, I do have concerns about the width of the new proposed Schedule B. So I was going to tackle this in 2 bases. Paragraph 3 to 9 of the draft order, and some concerns about B itself. So it may well be that the first of those fall away if you're against me on alternative 2.
Yep.
But the concerns I've got on B may yet remain.
Very good. All right. Well, that's helpful. Let's look at that again at 2 o'clock then. Thank you very much indeed.
All rise, please.
Yes. So what has happened over lunch is that my junior has drafted up a proposed revision of the order to incorporate the sorts of things we've been talking about. I've shown that to my learned friend. He has some observations that he would make. I don't have it in a form that can be provided to you, I'm afraid, at this point. But my learned friend has some observations. I think the way he puts it is that he's concerned in particular about the position of third parties in relation to documents that they might have custody of, but that he's not going to put up a fight, in essence, about the particular issues that he raised, albeit... what I propose to do is go through... I'll go through the order in the terms... I'm afraid, as I say, I don't have it on paper, and I'll highlight and flag up my learned friend's concerns and try to deal with them in that way, and no doubt he can interject if he wants to add anything, but that's how he's happy to proceed, if you're happy for me to do it.
Yes, and if you put all this in one order, I mean, I think what I'd actually had in mind was that the search order itself would be adjusted.
Yes, correct.
And you Schedule B and C, and I think that was the point that you hadn't quite grasped.
Yes,
probably because I hadn't said so.
We've firmly grasped that point now. So the first provision, in fact, of the proposed order is that the search order is hereby varied, such that Schedule B of the search order is replaced in its entirety by schedules, and we're going to call them B1 and B2. Yes. And so what we will have is, therefore, in this order, just a wholesale replacement of the existing.
Yes, very good.
Then there's some mechanical bits in relation to that, but they're just about rewording. So that's the first part of that order. Then the second part of that order is simply doing, in effect, lifting the stay that was imposed in July. So it says that the supervising legal representative do provide to the claimant's lawyers, not to the applicant as it had previously been, but to the claimant's lawyers, those documents which he received from Black Box and which he has determined are not, capital P, privileged, according to the definition that we had in the previous order. So it's not just the privilege, it's also the other orders that there are in England. And then the next one, which is a request that was made by the defendant's lawyers, the claimant's lawyers shall make physical or electronic copies of all those documents which it receives from Black Box, and as soon as reasonably practical thereafter shall return the originals, so they get back. Yes. So what that means is that the next bit is about the relevancy test, but that means we're not returning anything, we're just destroying our copies of it from that point forward. And so paragraph 5 says, if, upon reviewing the documents received from Black Box, the claimant's lawyers determine that a document is irrelevant to the substance of these proceedings or to any civil proceedings in relation to the same or related subject matter to these proceedings. That's a formulation of words that we had in a previous order. It in effect comes from the undertaking as to collateral use.
Yes.
That undertaking is, of course, limited to collateral use in Dubai and England.
Yes.
This provision is not, and the defendants accept that there's no reason to import that restriction, because at this stage we're looking at and retaining documents which might be relevant to any of these proceedings. Whether or not we are entitled to then use them, for example, in Malaysia or in the United States, is a later question. My learned friend has made clear that he doesn't waive any objection of that sort, and of course I accept that. We may need to come back to you and have an argument about whether we can take these documents to the USA,
Yes.
but that's for a later date. So if upon reviewing the documents it's discovered that they're irrelevant in those terms, firstly, the claimant destroys any copy of the document it has retained, and secondly, of course, the claimant's lawyers shall not show that document to the claimant.
Yes.
So that deals with the concerns of relevance that there were. And that, subject to the terms of the schedules, is that, and subject, of course, to costs, which comes later. So I don't believe that there are any particular observations about that wording. Some suggestions were made, some adjustments have been made to that draft. My learned friend, as I say, says he doesn't consent to any of this,
No.
but he's not got any other observations that he wants to make about that wording. So that's the wording of the order, and hopefully that's satisfactory. And then the next question is, what about the schedule? Now, in a sense, the schedule is there to legitimise what's provided for, at least in relation to black box documents, and their use. Well, not quite their use, but there we are. And so, in a sense, the schedules can be wider, because if we find that there are documents which are covered by the schedule, which come into our possession, but they are irrelevant, well, we'll have to destroy them and hand them back in with them. So it's not as critical to concern ourselves with the detail of this, albeit it's important, obviously, to get the groundwork correct. Now, what I say is that what we have on page 12 is adequate for the purposes, which sets out the various categories, and then by reference to the parties who appear in what will now be Schedule B2. Now, I have some additions to make to B2, because there is this new claim in London, so I think there are 8 further parties to add to B2. But I don't think that there are any arguments about the contents of the schedules, save one observation from my learned friend. So, what he was saying was, in relation to paragraph 2 of the schedule, he has an observation about the extension of the search order categories of documents to companies or parties who are party to proceedings in Dubai, but who are not party to proceedings in London. So he had a particular concern about that. And the point was about particularly property or assets owned by those parties. It seems to me that this is, and it's turned out that this is actually a very, it's important, but its practical effect is minor, because there is only one such party. So the schedule defines the category as any document containing information about property or other assets owned by what will be Schedule B2 parties. So my learned friend's concern is that there might be parties in Dubai, not in London, who are non-causal action defendants, and therefore it might be inappropriate to extend the information search order to cover information about those parties' assets. Now, of course, our primary position is, well, what's the difference? Because if those parties are defendants in Dubai and Elysium Global has information about their assets, then it is disclosable on Norwich Pharmacal grounds on the basis that it will be relevant information to allow us to enforce ultimately against those parties. The particular individual company is called Novus Capital Markets Limited. I'm told it's a broker. I can't give you any further information today, I'm afraid, as to exactly what their role is, beyond that they're some sort of broker. But I suspect, therefore, as a broker, the allegation will be that they were somehow caught up one way or another in the fraud. But I don't have any detailed submissions on that. So, I mean, my learned friend says, well, he's not going to get terribly upset about that one individual party. It's just one party. And my position is going to be that if the defendants have information about that party's assets, then they ought to be disclosed. But that's the one discrete point he makes in relation to paragraph 2.
So where do they appear in the schedule?
Testing. Thank you. Thank you very much.
13, thank you.
I've been bailed out.
Schedule C is the second block down.
Yeah. Number 8. The point was raised just before lunch. We have emailed OGH, who are in charge of the Dubai court proceedings, just to try to get a bit more information about the nature of the claim against them. But I'm afraid I don't have that information for you at the moment because of the way that the issues are arisen. But it's not known. I don't believe that Novus Capital Markets is a party whose name appears on the label of any box, but I can't be sure. So there may not be any documents. This is a bit belt and braces in that respect, because we're dealing with all defendants in all jurisdictions. But I mean, ultimately, it's not obvious to me why it matters that the party's being sued in Dubai, not in London. Because if there's a claim against it, the principle's the same. So if the defendant's got information about its assets, then there's a justification for providing that information. And as I say, I mean, if ultimately the information that is held is not relevant either to enforcement or to a claim, then we'll be returning the documents pursuant to the original order. So I would suggest that we just leave paragraph 2 as it is. I don't know whether my letter wants to make any further additions in relation to that.
No, just to explain my position. Look, I've given in on black box, so I don't want to give in and have a trench warfare over one company out of many. I have left an issue over the let's say, wisdom of the onshore proceedings in Dubai, what jurisdictional effect that might have on these proceedings, and if so, what effect that would have on the search and seize order. So, my concern, this is how to raise, my concern was simply that if everyone in Dubai onshore has been sued in London, so it doesn't matter, because if they've been sued in London, they've been sued in London, then that will do. But if there's somebody who's only been sued onshore, then this order, in effect, will give SKAT documents relating to them in circumstances where the wisdom of that could be called into question subsequently if the search and seize order is premised on a fraud proceedings jurisdiction. So that's how it arose. So I'm not, as long as the court's aware of the problem, I don't represent Novus. So I'm not trying to stop anyone seeing the documents. I have no reason to do that. So far as the relation of US companies is concerned, again, it's not a matter for me, in those circumstances, to say anything about them. I'm in the position, if you like, of a bank and an NPO. The court must order what it orders. And I've just left it on the basis that no, as I understand it, no use can be made of any of this material by SKAT if they're not already being sued offshore and in London. Without coming back to ask Your Honour's permission to do so. And if I've got a point of principle that was emerged by then, it's agreed that I can raise that point. I can raise that point of principle then, not now. So that's why I'm completely neutral about it. I just want you to understand why you've identified the question, so that Your Honour takes a decision knowing that there's one included.
Yes.
Not in London, that I know nothing about and don't represent.
Yes.
And I think that, in fairness, the other observation that a friend has comes from a similar place, which is that paragraphs 3, 4, and 5 of this schedule define documents about transactions, about WHT claims, and and the use of the proceeds of WHT claims. And his suggestion, his observation, is perhaps that ought to be limited by reference to a time frame. And I think the response, and his concern was to preserve the position of third parties who are not here. This is not, however, a third party application, because these sorts of documents will very likely be relevant to the claim for conspiracy, because anything to do with the WHT application will be part of the conspiracy that I will need to establish in some forum against the defendants. And if they are not relevant, then, as we all know, then they'll be destroyed. So it's not really a huge concern. I mean, I would observe that in relation to 4 and 5 in particular, I mean, if we impose the time frame, say, of 2012, which is when we know that this problem started, then this would not permit us to search for and retain documents which related to any earlier WHT claims. So if you find documents which relate to earlier WHT claims by the same parties, then clearly we'll want to investigate and they're likely to be relevant. Even if no claim is made in relation to those WHT claims, the documents are almost certainly going to be relevant to the subsequent WHT claims, if only to show the differences between the WHT applications or the methodology used, or some sort of similar fact evidence. So again, I don't think my learned friend puts it any higher than he wants to make the observation that he made. The original order, of course, doesn't provide for any time frames, doesn't include any restriction on the time. So the effect of this observation would be to restrict not just the disclosure which is being ordered, the additional disclosure which is being permitted now, but also what has already gone before will actually be cut down rather than be expanded. So that is why our approach has been simply to amend the parties but not the definitions. So the definitions remain the same. The parties to whom the definitions are to be applied are expanded in the form of Schedule now B2. So again, I mean, my position will be that fundamentally this as drafted, this ought to remain in the form that it currently has. There's always the fail-safe of the relevancy test that comes later. Unless my learned friend wants to make any further observations on that or anything else.
Let me just explain. The paragraphs 4 and 5 of Schedule B, those Schedule B are new, but they don't appear in the original, and new ones. And if and insofar as the one is making an order which has third-party disclosure or Norwich Farm or base to it, it's common ground that it's exorbitant. It's common ground that it's not restricted in the way it is in England by the 1975 Act, so I haven't got any difficulties about that. But all my purpose is to have on the record which one has been asked to consider whether the, or one view, very wide form of words in 4 and 5, and the absence of any timetabling, time limits, are appropriate for an exorbitant order of the nature we're talking about.
Do you want to suggest a time limit?
Well, in a sense, not for me to do, because that's the difficulty I'm in, because I'm not representing the people who will be affected by this. I can understand Mr. Montague-Smith's position that if he starts in whenever it is, I think it's July 2012, through to the 35-month period, I can't remember precisely when it starts, but to the 35 months of 2012-2015, that might not catch everything. So one might think a couple of years either side would do the job.
Yes.
If you thought it proper for parties who are not here to impose a restriction, I'm not saying it's not open to Your Honour to consider on the balancing act that you would have to do under an MPA. No. This is appropriate. I just wanted to observe that someone had brought that to your attention before you, as it were, sailed in without my objection to the width of 3 and the new 4 and 5 in those terms. But as I say, I'm not trying to be difficult over it. I've given it a black box. I just wanted to make certain that it's being looked at in that.
Can I just make clear the basis for this? It's in part that this evidence these documents might be relevant to other proceedings elsewhere, but fundamentally, this relates to information about WHT applications, and that will be relevant to the claim against the first offender. So these are documents which, if there are documents that answer that description, will be held by the first defendant relevant to the claim against the first defendant. So there's no issues equivalent to 1975 Act issues that even arise in relation to that. And then the second point is simply if one considers the practical effect of imposing a time frame limit, what we're doing is we're saying you should exclude withholding tax, information about withholding tax applications that predate the ones we know about. And if there are those, as I've said previously, if there are such documents, then they're highly likely to be relevant to the claim. If they're not relevant to the claim, we'll destroy them, pursuant to the other part of the order. So as I say, I understand fully why my learned friend makes those objections. I also understand, I think, why he makes them in the way that he does. He doesn't go into war for them.
But it's not likely to have any practical impact. It's really important because if it's in the defendant's possession, then it's presumed to be likely to be in connection with the scheme.
Correct.
Putting it in neutral terms.
Yes.
Well, right, I would categorise everything I've said as an observation for the assertance of the court, not an objection.
No, I understand entirely that. In the ordinary way, I think one would put in a time limit, even if it was a very wide one. But I think in the circumstances, because it's focused on the first defendant and so on, I don't see the problem.
Great. In which case, I think that is all that I had to say about the substance of the order, which leaves us, I believe, just with the issue of costs.
Well, the other thing that remains, I suppose, perhaps it comes after we've dealt with costs, is whether there is a need to schedule a further hearing. I keep scheduling hearings in the hope that there will be something rather more conclusive than anything we've done so far. But there's a question of trying to be realistic here as to what's likely to happen.
I agree with that. We'd make one observation, which is that we scheduled a hearing long in advance in this case.
Well, I'm sure you were going to say that.
And much good that did us.
Well, I understand.
Well, yes, and I see that. I mean, I'm not averse to the court scheduling a hearing, and I can see the benefits of that. I don't have diaries here.
No, I wasn't going to suggest we did it here and now, but if both of you think that it's inevitable that we'll be having a further hearing sometime in the course of between now and December or something, the sooner one gets it on the books, the better. Find a time that people can do and determine whether it's one that can properly be held with a video conference, or we have to come trooping out here.
I see the wisdom of that. I mean, I do have some slight reservations, which has been that to the extent of evidence in this case, which is if we schedule a hearing, then things can be allowed to drift until the hearing. So to me, parties can say, well, there's no point in grappling with it now.
Well, I understand that, but on the other hand, trying to do something at short notice is equally a problem because of people's availability, isn't it?
No, I see that. So
perhaps you'd like to think about it between yourselves and
yes.
come back to the court and say if you want to try and fix some hearing on a provisional basis, and we can abandon it. It's not necessary or whatever.
Well, I'm pretty confident we do need it. I'd be trying to think over the short judgment where we're left potentially, unless we can sell limestone 2 and 3 and get the onshore money. There won't be enough for us to do everything we need, including backfilling September, the cost project, the hearing in London, and any chance of putting together a defence or any semblance of doing anything here in relation to the SSF. So, absent that happening very quickly, we're out. The defence will collapse. So,
in which case, in a sense, the burden is on you to be able to put together what you would regard as something that will persuade me as to the need for funding, and how long you're going to need to do that. For Mr. Montague Smith to reply, and you if necessary to put any further evidence you wish in that context.
Leave aside the question that there's no funding for that exercise currently. I'm not being difficult, but
I understand, but I've given an indication about that, Mr. Jones, which I hope is of some assistance.
But at the end of the day, we must do what we must do.
Yes.
And I'm not saying anything untoward, but I would have thought a hearing would be essential for us to know that we can come back and come back quickly, because this will unravel if we don't. And that would be a shame. And one of you will understand the difficulties of proving a negative. So we've borne in mind what you've said, and we will come back and do better. And that's just the way it is, and we must accept that, as we, of course, with respect to.
Yes, and if indeed, as one assumes, the DIFC order will be recognised and fully effective in onshore Dubai shortly, i.e. the banks acknowledge the effectiveness, then there's room for the release of the £250,000 that I've indicated.
Well,
hope you're on your way, should we say.
Well, you want to... when you next hear from us, you will have chapter and verse as to why that isn't going to be anywhere close to...
Oh, I appreciate that, but let's see you on your way, as I say, with the things you need to do in the immediate, and perhaps recompense you for matters not compensated thus far.
I do make it clear to the learned friend that I'm going to be writing to them very shortly, saying that they should agree, regardless of the honest observation, to agree to release the full million the moment it's releasable. But I just want to make sure I'm not... No one's misunderstanding that I'm proceeding on the basis of 250,000.
I'm not hamstringing you in any way. I've merely given an indication.
I understand. Thank you.
So now we're going to approach the next subject of costs.
Costs. Well, all of our time getting ready for this hearing was spent on the black box application, other than what we spent after, I guess, my letter for a skeleton argument was really received on Saturday. I got it on Friday morning, I think, and then I was on a plane for the day. So I would suggest that it's difficult to see any other solution. The cost should follow the event of the application that I made, and the order that Your Honour has made or is about to make is very much in the terms that we were seeking. I've made my observations about the timing of the way in which the response to this application has been dealt with. We spent it's not just the cost, it's also the time. We haven't had those documents from Black Box for the 2 months or whatever it is, and I can't remember exactly what the timing is. The defendants have maintained an objection. They maintained that objection right up until Wednesday night. Wednesday night they served evidence in which they said we will object to this application. So something has happened between Wednesday and when the skeleton argument was filed on Friday. But we don't really know what that is. Now, it's said that a pragmatic approach is being taken. Why a pragmatic approach couldn't have been taken before? There's no explanation. But ultimately...
I think it's very clear from what Mr. Jones said. They had a meeting last weekend.
Why that meeting couldn't have happened earlier? Why we had to go through the expensive and delaying process? I mean, ultimately, the defendants have achieved a degree of delay, and what the effect of that has been is that we haven't had these documents while we've been putting together the particulars of claim in London. I say we, but I haven't really been involved in that. And our particulars are due on Wednesday of this week. So they've achieved that delay. They ought to pay for it. Cynics would say that was part of the plan, but here that it's not.
Yes. Degree of unreality about this, but also lack of accuracy. First of all, Black Box LPP expired on Wednesday this week, so in terms of being kept out of the Black Box documents for 2 months, I don't think that's strictly correct. Secondly, everything we've been dealing with today, including our agreement in relation to Black Box, is essentially a case management issue. It's cost, it's release of funds, it's resources to manage what is required of us, and to prioritise different aspects that are required of us. So the starting point, as far as I would be concerned, is there should be costs in case, nothing more. In terms of the criticism that we couldn't actually convene a bunch of lawyers from 3 or 4 different countries earlier than at 14 days' notice, it's, frankly, if I may say so, not well founded. But I'm not going to go to the stake over it for this reason. It shouldn't be costs in case. That's my submission. Costs should only be ordered on the express basis they're not to be paid until the conclusion of the proceedings, both in here and in London. That's my submission. So if you want to order costs, so be it. That's a discretion. You don't need to hear for us a long period of time over that. But the reason for that restriction is as follows. If we win the case and defend successfully, this will be a drop in the ocean to offset against the costs that SKAT will have to pay to the defendants. If we lose, then SKAT is simply spending its own money in asking you to pay for it now, and all they will do is exacerbate the funding problem that I've already got because I can't pay. So if, for example, you were to make an order which stands with the fate of the DIFC proceedings, then I can't be left in a position where I agree for case management reasons and good reasons to move the DIFC proceedings to London, and then find that we've got to find cash that we need for something else to pay an interim costs order, which if we win the case, have to pay us back. So at the end of the day, this is all absolutely irrelevant in reality. And I go by that to minimise the importance of the argument, but it is actually irrelevant if it's ordered not to be paid until the conclusion of the principal proceedings here in London. And that is my submission. Beyond that, I've got nothing else to say.
While you're inviting me there to accept that there isn't a possibility that you'll pay it in the interim, you're inviting me to accept that if I made an order in Mr. Montague-Smith's favour, he would not be able to pay it. And that may beg a question or two.
Well,
we're back to the question of your financial situation and funding and so on and so forth.
Yeah.
Which, as yet, we haven't determined. We being the court.
Well, you want to then put it off until you have determined it, would be my alternative submission. Because if the rod from my back is made stronger and longer and thicker, I've got to spend more money firefighting collateral issues. And what cannot surely be fair is for collateral issues of this kind to give SKAT any sniff at advantage of winning this case without having to prove it in fighting. And that means me surviving. And one of us, I would hope, accept that we're still in the game here. We're giving it a go. No one's made a decision where we can't defend this. Neither should they or could they. And the learned friend has not asked for an interim order, and neither should he. And if he does, Your Honour shouldn't grant it to him. But I would ask you to go a stage further and say that for the reasons that I've expressed, this is not a typical pay-as-you-go case. Because if it's a pay-as-you-go case, then the money is coming out of their money in due course, unless they're confident that there's more than 2 billion sterling, including compound interest, being hidden, which is pretty unrealistic on any footing.
Mr. Montague-Smith, I'm inclined to make a rule of costs in your favour, not to be enforced without the further permission of the court. Do you want
I can understand.
argue for anything else?
That's fine, because just so I'm clear, I mean, it seems to me that what's being said at the moment is that there are immediate funding problems.
Yes.
And there are funding problems that will persist until the end of the case. So once established and once resolved, if those funding problems evaporate, then there's no reason to...
Well, that's why I say not without
And
the permission of the court, so it can be
fully understood.
broached at a later stage should the circumstances warrant it.
Understood, yes. So in those circumstances, I don't think I'm going to ask for an interim payment on account, albeit what I would like to make clear is that I'm not losing the right to make that application for an interim payment at a subsequent date. So in other words, my application for payment could include...
Yes. You weren't going to ask for summary assessment in any event?
No, I wasn't going to ask for summary
So
assessment.
it would have been an interim payment on
Correct.
account regardless?
Yeah. I mean, it may be that I come back and we have a date fixed and there's an appropriate time to have a summary assessment at a later date. I wouldn't want to tie my hands on that, but an interim payment is much more likely. I can accept that.
I've forgotten what the rules are here, but you probably have to have a schedule served 24 hours in advance, don't
Yes,
you, technically,
probably.
if you want a summary assessment?
You probably do. Yes.
Same as you do back in England. Yes.
So no,
So it's interim payment only, should you
understood.
broach that later?
Which just yeah. So yes, and that's the other point. Is just in terms of which costs we're dealing with. Are we dealing with? We're dealing with the cost of my application,
Costs of both
and
applications.
the cost of both applications.
And there'll be two separate orders.
Two separate orders.
Yes, because what I'm going to simply do with Mr. Jones's application is adjourn it. I'm going to adjourn it, and then there'll be a schedule of reasons, which will be the extemporary judgment that I gave earlier.
Thank you. But in terms of the cost orders that Your Honour is making, there'll be the cost order in respect of the application that I made, but also the cost order
Yes.
in respect of the application
Indeed.
he has made to date. Yes.
Indeed.
I understand.
Thank you.
Well, I just invite you to consider a refinement of that. The application we've made last night was in fact adjourned.
Yes.
So the cost order that one is about to make would embrace the cost order occasioned by the application typically. But if we come back on an adjourned hearing and win it, then part of that would not fall to the plate today. What I think you want to isolate at that point would be the cost of today. So without tying ourselves up in a knot, it may well be better simply to, as it's not going to be enforced immediately, to adjourn that to see what happens on the next occasion, because actually it might be a complete order if you're against us next time, or it might be a partial order, but in that point we'll need to know, and we'll have the material to know which part.
Well, it would be more easily expressed, would it, as the costs of Mr. Montague Smith's application and the costs of today
And the cost of today.
leaves.
So I'm content with that because it leaves it open. The only other point I wanted to raise, and that concerns the point of some remaining points of contention in relation to the privileged material which has emerged from Blackbox. So that's an issue between, at the moment, us and the SLR.
Yes.
Who's not here today, of course. And the potential problems are twofold. One is a question of construction or interpretation of the order so far, and whether that needs to be amended. And secondly, that's not being brought back for you today because we haven't actually reached the end of the argument about whether we do agree with him and he agrees with us as what is the privilege, leaving aside the definition. So that's going to be resolved, we hope, in the next week or so. So another reason for having a further hearing might be, if we can't resolve that with the SLR, is to wrap that in at the same time.
Understood, but then do you have a problem about what judge has to decide? Because looking at privileged material, mate, I don't know.
Well, I'm hoping not, because let's hope for the moment that the issue between us would be an issue of interpretation of the order, the width of the order,
Right.
which your order could happily deal with.
In the abstract.
Yes, in the abstract. And I'm going to hope and pray that we don't actually have to come back and argue about which document falls into which category, because I think it's fair to say that both sides have made progress on that, and the SLR and Davison's have been reaching closer and closer ground. So I'm hopeful that won't happen, but it might. You're right, it may not be possible, but the idea that we're coming back and arguing anything with the SLR will actually cause us all to agree what I can call the fragmentary design.
Yes, very good. And just by way of information, so far as you can, when would you hope to come back to this court with a further application?
Well, on a practical level, I'm due to be on holiday from next Monday for a week, so the 1st to the 9th of October. But my personal convenience may mean that I have to be substituted, but that's difficult. Because
not realistic.
Well, there's no funds for anyone else, so it's going to have to be someone who's, like me, feels
Yes, but it's
feels
also
obliged to turn
someone
up.
who's familiar with it, so
Yeah.
realistically it's got to be you, isn't it?
The long stop that seems to me to be the fair long stop is the 12th of October, so I get back on the Monday the 9th. And we're in front of Mr. Justice Jacobs or a colleague of his on the 12th. And it would be a shame if my function is at least in part to knit these claims together and give everyone an overview. If all I can say to him on the 12th is that we're not running, and I've been unable to resolve that so far in Dubai, I've got a hearing, but I'm going to go back and it's next week. Because so if I was looking for an order of preference, it would be to come back here before we have to do the 12th, but that's looking extremely difficult.
Right.
Because if I'm back in the UK on Monday the 9th, I think in reality it would have to be a telephone hearing, because I couldn't fly out and fly back and perform in London on the 12th and retain any kind of concentration, I think. So I would have thought that is the period we should aim for, if we possibly can, if you're always prepared to accommodate it on a telephone basis. I haven't discussed this with Dr. Smith, so I don't blindside you with the suggestion, but that's what I have in mind.
I'm in arbitration 8th, 9th, 10th and 11th.
Right.
That doesn't mean it's not possible at one end of the day or the other.
I mean, the difficulty with it is, of course, as Spartacus will say, I'm sure, is that if we're coming back that quickly, that makes evidence and skeleton exchange actually pretty difficult.
I think it does.
But the difficulty is, I would like to be able to make progress before the 12th if I can, but if I can't, I can't. That's it.
Yes. Yes.
I mean, it seems to me if we're going to fix a hearing, we really need to have directions for evidence and exchange of skeletons and all the rest that are adhered to. In terms of my personal availability, I think I'm in prep for something in December. It's got something quite heavy in December. So, you know, I can
Taking
fit something
the odd
in.
day is not a problem.
Yeah, quite. That should work, but I do have
Well, I think
reservations.
realistically this isn't going to happen before the 12th of October.
No.
And the right thing to do is for you to liaise as to what a good day might be and try and agree a timetable of exchange of evidence. And then I'll make an order on paper to that effect.
Yes.
If
Understood.
you can't agree, I'll make a ruling on paper to that effect.
Having lost substantially today, I'm going to retain my optimism. When we send our next affidavit to Mr. Montague this fine, they must agree that we can have our money. That's what I'm hoping, and we won't have to come back to it at all. Well,
It's not quite the question issue, but there we are.
Sunny optimism is always welcome, whatever quarter. Nothing else for me to do at present. Thank you very much. Yes. Just trying to work out what to do about documents. So, I'll take these up. Thank you very much indeed.
All rise, please.